against eviction. So it may be taken tomorrow because date of eviction is fixed on Monday.
Okay.
Obliged.
My lord, this matter will be listed for admission on Monday, my lord.
Why
Matter
Monday?
relates to, my lord, non-payment of arrear salary, my lord. Of the
Area
petitioner.
salary?
Yes, my lord, the petitioner of the assistant engineer under the PNRD
It's not,
department, my lord.
that's not,
PNRD department. Earlier it came in bench 4, my lord.
huh?
Earlier it came for motion in bench 4, my lord.
Yeah.
Notice was issued.
It's a bench tree matter.
PNRD, my lord.
Huh. Bench tree, isn't it? Bench tree, you mentioned it, bench tree.
No, that's it.
Oh.
Your lordship, my lord, please, the matter may be listed the next week, my lord.
What matter?
For compensation for death in the riot affected people. It's 2016 matter.
My bench.
Yes,
Okay.
May I please, your lordship?
When do you want?
Monday if possible, my lord.
Oh. 30 April.
May I please?
Yes.
I beg to mention about item number 9 of the discuss list.
Well,
I am for the respondent number 1, 2, and 4. Today morning, we have filed our wakalatnama and we are filing affidavit opposition today. So matter may be
My lord, I
adjourned
am
for the
appealing
day.
for the petitioner, and today it is faced for consideration in interim order, my lord. Let the matter reaches, my lord, your lordship.
Actually, your honor, the respondent, the personal appearance is giving by the respondent, but the person has not came from Calcutta. And another thing, your honor,
let it reach. Let it reach.
That
We'll
is
see.
much.
What personal appearance?
It is not required, my
your
lord.
honor, DGM law was personally appearing in this matter
Let us see the
initially.
file. Let us see.
And another thing, your honor, the documents, the tender documents which was supposed to file by the petitioner, they have not filed anything for us. And we have not received the affidavit opposition filed by the petitioner, respondent number 5 also. So as at least the matter may be adjourned for the day, your honor.
Now my case is very clear, my lord. Your lordship may kindly see
I think we'll change, your
The
honor, if
arbitrary
the matter
action-
is adjourned today.
only 2 documents will prove the arbitrary action taken by the respondent.
What personal appearance? There's no personal appearance.
No personal appearance there.
On last
Let
2
the matter
occasions,
be
he was
decided.
appearing for respondent number 2 and 4.
Huh? He was there.
Yes. Also, your honor, we are filing affidavit opposition
Let
today.
it reach. Let the
Yes,
matter
yes,
reach.
my lord.
Okay. Let
Yes.
the matter reach. We'll see.
Your lordship, I am for respondent number 5 in this
Ah.
matter. We have filed our affidavit in opposition yesterday.
Let it reach.
The same is not on record. May it be called, your lordship.
Let the matter reach. Huh?
Lordship.
Okay. Call. Yes.
Hey, please, your
Oh.
lordship, I beg to mention a repetition for tomorrow, your lordship, for motion, your lordship.
Why tomorrow?
Lordship, it's a contractual matter, your lordship. The technical bid has been rejected and the financial bid has been opened. Where L1 has been selected, but LOA has not been issued yet, your lordship. Any moment that may be issued, your lordship. Under that apprehension, we have filed that repetition challenging our.
L1 has been selected, isn't
Yes,
it?
yes.
L-
LOA has not been issued yet, your lordship.
Let's see. Okay, tomorrow.
Deeply obliged.
Matter relates to non-payment of admitted amount of contractual bid. The matter was last listed on February, lordship. Thereafter, 3 weeks time was granted to file application, and matter has not been listed, lordship. Any week, any date on next week, lordship.
Second.
Second,
May I please,
Obliged.
your lordship? My lord, I beg to mention a contempt case for withdrawal
When do you want?
uh,
Next week?
next week. And another prayer, my lord, I
30.
beg 30. I beg to mention a writ petition for listing for motion, your honor, 28. My lord.
For motion fresh matter? What the urgency?
Warrant attachment has been issued against.
Okay.
Obliged.
Lordship, with the consent for the senior counsel appearing for the petitioner, Lordship, I beg to mention item number 12, Lordship. In this matter, we are for the respondents, Lordship. Lordship, today my senior, Mr. A. Sharma, is out of speaker, and K. Kalita, who is assisting in this matter, was supposed to come today, but due to some health issues, Lordship, he could not come, Lordship. So kindly maybe taken up at after like 1 week now, Lordship.
You are for the item 12.
12.
Where's Das Gupta? Have you taken his consent?
Yes, yes. Let me get the.
Okay, on request made on behalf of Mr. S.N. Sharma,
A. Sharma, Lord.
on request made by Mr.
The-
No, you are appearing on behalf of whom?
Mr. A. Sharma,
A. Sharma is not there.
son of S.N. Sharma, Lord.
Okay. Okay, on request made on behalf of A. Sharma, learned counsel for the respondent.
Yes, Lord.
List the matter after 1 week.
Lordship, Mr. A. Das Gupta was insisting for a date, Lordship. Can it be on 8th May, Lord?
8.
Hello.
Item 1 of daily list, motion.
I have filed the affidavit, being on record my rate.
You
My
file,
rate-
when did you file your affidavit?
I just filed on yesterday.
Okay.
Government is also filing a affidavit.
My affidavit is also ready, Lordship. We have already served copy, I think. And we are filing during the course of the day, Lordship. So what I am submitting, Lordship, instead of today, Lordship, if Lordship takes up this matter on a fixed date, Lordship, it will be convenient for the petitioner also if he wants to file any reply.
May I create on first, next week, on first.
Is it all right, Saikya?
Lodge.
Mr. PG Saikya and a senior counsel submits that they filed an affidavit. When?
In between, I'll file.
No, when did you file it?
Yes, sir.
Yesterday I have filed, so far as my affidavit is concerned, not 23.
Additional affidavit.
My lord, pursuant to the order, my lord, I have brought on record my rate. Additional affidavit only to the extent of bringing on record my lord.
Okay, has filed an additional affidavit disclosing his financial bits. When did you file it? Yesterday?
Yesterday,
On, yesterday was 23rd.
23rd.
Registry to verify and place the same on
Party
record.
one.
Being found in order. Mr. P. Nayak, London Standing Counsel, PWD also submits that he would be filing his affidavit within the course of the day. Stop it. Accordingly, list the matter on first May.
First May.
Lordship, I have only one small request, Lordship.
Can it be on 7th, my lord, because I have to file the reply in between, my lord.
My lord, I have just one small request. Lordship. My colleague will ensure that his affidavit, his reply is filed at least 2 days prior to 1st of May, Lordship.
Today is 24.
That will
I
be
have
on
to-
record,
I have to
Lordship.
file it
And
in.
1 week time he has,
within
Lordship.
2 days, my lord, I have to file, my lord, what days submit.
The learned counsel for the petitioner is also permitted to file reply to the counter filed by the PWD department.
Yes.
By the PWD. Huh? Before the next date fix. List down first.
The interim order passed.
Interim order partially to continue. till the next.
Obliged.
18 of supplementary list, motion.
May I please, your lordship, my lord, hearing this case, petitioner is before your lordship for rejection of her.
PNRD.
Yes, I am appealing for PNRD.
But I represent the State Election Commission. Before my learned friend addresses your lordship first, I am raising a question of maintainability. Because your lordship has decided that calling of a rejection of nomination would be part of an election process.
Yes.
So under 129 B, my lord, it has to be challenged by way of an election petition.
I will satisfy your lordship in that respect, my lord. Let me submit, my lord.
Yes.
My lord, your lordship may kindly please annex to page 23, my lord. That is the press release by the Election Commission on 28 December, my lord. Page 23.
Yes.
The final electoral rule for ensuing panchayat election have been published after taking into account effect of fresh delimitation of Gaon Panchayat, Anchalur Panchayat and Jilla Parishad constituencies by the Government of Assam 2024 for 27 districts excluding six scheduled areas, municipal areas. The electoral breakup as per final electoral rules after disposal of all claims and objections received for 27 districts is given below. Thereafter, my lord, my name has been appeared in final electoral rule, my lord. That I have annexed it as space, my lord. 30, my lord. That is translated copy.
Page,
30, my lord. Translated copy and original copy as page 31. Lordship found. My name is appeared at 234, my lord. My name is Onamika Das, my lord, husband number, and from ward number 8. That is the final, type of amendment, final rule. Type, date of-
ward number 8. Okay.
Yeah, Lordship got it.
Hmm.
28/7/24, my lord.
Hmm.
That my name is appeared in respect of ward number 8, my lord, in the final electoral rule, my lord. And then, my lord, your lordship may kindly, next state, my lord. Then your lordship may kindly come to page 36, my lord. In this respect, my lord, block development officer issued the certified copy of electoral rule, final electoral rule. That is also type copy, my lord, because these are Bengali in.
Hmm.
Ward number 8, my lord. My name appeared against my house number and serial number, my lord. 234, 231, my house number from ward number 8, my lord. Then, my lord, at page 38, my lord, the block development also issued the certificate about my tax clearance, my lord. That is at page 38. That here, my lord, also mentioned page 39 also, my lordship may look at, my lord. Has not used whatever from financial year 24-25, my lord. From ward number 8, my lord, and my list of voter holding list number 231, my lord. That is my house number, my lord.
Yes.
And then concerned Gaon Panchayat also issued certificate at page 40, my lord.
Okay.
And 41 is the xerox copy, my lord, of that certificate. Here also mentioned about ward number 8, my lord. That I belongs to ward number 8 of Gaon Panchayat of Chengduar Gaon Panchayat under Tapang Development Block, my lord. Then, my lord, I have submitted my nomination paper here at page 42, my lord. They have received my nomination paper, my lord, at annexure 10, my lord. Page 42, annexure 10. Next page is xerox copy, my lord.
Okay.
And it will be, nomination will be scrutinized at office of the BDO Tapang on 12/4/2025 at 10:30 AM onwards. At page 44, my lord, that is the impugn order, my lord. And then next page, my lord, page 45 is the xerox copy of the order, my lord. I have scrutinized the nomination paper under section 22 of subsection such and such decided below. The candidate is not an elector of constituency, that is ward number 8, 98 Chengduar GP. She is an elector of ward number 7. GP number 8, same GP, but ward number is different. Hence, as per eligibility or not fit, hence rejected. In the bottom, my lord, then the block development officer written, my lord, candidate belongs to ward number 7 as per latest electoral rule generated on 33/2025, my lord. The next is xerox copy, my lord. And then, my lord, I have also annexed that, my lord, electoral rule of ward number 7, my lord, at page 46, my lord. That is draft electoral rule, my lord. Page 47 is a xerox copy, my lord. The date of amendment is 11/12/2024. Type of amendment draft rule, date 1/1/24, and my name as page serial number 55, my lord. That was also verified by the block development officer, your lordship, found at page 48.
So your name is in ward number 7.
Ward number 7. But final electoral rule, my my name is ward number 8.
This is what roll? This is the final roll.
No, my lord, that is a draft rule, my lord, your lordship, page 48.
Page 40.
8, my lord. If my lord in the final rule, in that case, I have no page, my lord. Page 48, my lord, recent electoral rule verified by the block development officer.
Now, how do I know that this is the
My
final
lord,
roll?
this is original copy.
No, this I've seen. This I've seen. Now
In
this,
the bottom, your lordship verified by them, my lord. Block development officer who had issued the certified copy to me, my lord, I have already shown your lordship.
hmm,
In respect of ward number 8.
okay. No, how do I know that this is ward number 8?
My lord, from the final electoral rule, my lord, and this is the draft rule they have given to me, my lord.
No. Which one is the draft rule? Which one is the final rule?
That is the draft rule, my lord. I have
This
said-
one.
Yes, my lord.
Okay.
And final rule, I have already shown your lordship, my lord, that
Page.
page 32, my lord,
Page 32.
my lord. That is the final and my name appeared at 234, my lord.
Where's the type copy?
And the type copy, my lord, it is page 30, my lord. And 31 is the details, my lord, of xerox copy of details.
Okay.
Your lordship got it.
Yes.
And then, my lord, against this, my lord, rejection, my lord, I have approached before the district commissioner, my lord, by filing a representation at page 49, my lord. And page 51 is my prayer, my lord. That your authority will be kind enough to take appropriate steps so that my candidature will be accepted and thereby I shall be able to contest in the ensuing Panchayat election 2025 for the post of member of the group number 8 of Chengduar Gao Panchayat. That is my prayer before the deputy commissioner. That is returning officer of the district, my lord. But same has not been unattended, my lord. And due to this reason, I have approached before your lordship. And illegal action of the malafide action, my lord, I
It's
have,
an election matter.
my lord,
Alam.
I have a peaceful judgment of 2008 SCC 216, my lord.
No. You approached the appropriate forum.
That's true, my lord. But here, my lord, I have shown your lordship has the power. Para 30, 31, 32, my lord. And 32 is relevant for my case, my lord. Subject to the above action taken. Parameters enable the petition to everybody such as
Page. Para.
Para 32, my lord. 30, 31, 32, my lord. But 32 is relevant for my case, my lord.
30.
30, my lord, that to what extent to 329 B has an overriding effect of 226 of the Constitution. Two constitution benches have held that Representations of People's Act 1951 provides for only one remedy, that remedy being an election petition to be presented after the election is over, and there is no remedy provided at any immediate stage. Non-abstency clause of which the Article 329 offense pushes the Article 226 where dispute takes the form of polling in question an election. See para 25 of the Mahinder Singh Gill's case. The provisions of the Constitution and the Act read together do not totally exclude the right of a citizen to approach the court so as to have the wrong done remedied and by invoking judicial from. Nevertheless, the lesson is that the election rights and remedies are statutory. Ignore the terrifies even if there are irregularities or illegalities and knock the door of the courts when the election proceedings in question are over. To prevent the attack on anything done during the election proceeding is to avoid it. One, during the course of the proceedings, and the other at its termination. For such two-pronged attack, if allowed, would unduly protect and obstruct the functioning of the democracy. And then page 32, your lordship may come. Para 3 is, I'm relying on my 3, 4, and 5 million.
What is your prayer?
My prayer is in my writ petition to allow me contest the election, my lord, at page 15, my lord. Certiorari should not be issued the quasi registration order and for nomination for independent petitioner for award number Chengduar Opposition allow the petitioner contest and show in elections to be held to 2525 for group member of ward number at Chengduar Opposition.
Your interim prayer?
Interim prayer, at this I am not pressing, my lord. I am only praying before your lordship. If my representation is pending before the deputy commissioner, my lord, deputy commissioner may decide the issue, my lord. That is my prayer, my lord. I have not obstructing or anything, my lord.
Yes.
Wait, please, Lord.
129.
Lord, your lordships, Lord, in an earlier round of litigations I held that rejection of nomination would come within the purview of the term election. And once election process is on, my lord, it can't have any interference. And the remedy is of filing an election petition. I'll rely upon.
That is after the election, my lord.
Yes.
So that's obstructing, my lord, my lord. After election, my lord, I have no case, my lord.
Why not?
And,
Why don't you? Why would you
and-
have a case? You'll have a
in-
case.
In that.
You have a case.
Yes, so here a good
In-
case. If
in
it
that
is
case,
not for an election petition.
Another, I have also relied, my lord, that is Uttarakhand High Court, my lord, Nonital. Here in this case, their local bodies election or their nomination is rejected and the court allowed the my lord.
But in the judgment which has been relied by my learned friend, Apex Court, which says, my lord, if there is an direction for facilitating elections, my lord, then your lordship can interfere.
And in that judgment also, my lord, your lordship may kindly, para 26, my lord, the court finds is therefore the returning officer of finds that therefore the returning officer overstepped his authority by unilaterally declared the SSP number so and so. The petitioner encouraged absence of any adjudication that I have escaped, my lord. And para 27, the actions of the return violated the principle of natural justice. Since, my lord, I have not been also heard, my lord. In the Panchayat Act also, prior to rejection of my candidature, my lord, they should heard me, my lord. Opportunity given me. But in here in this case, my lord, there is no opportunity given to me. Natural justice infringed upon the petitioner's fundamental right granted under Article 14 and 21 of the by denying the petitioner a fair opportunity to present his case. Returning officer failed to uphold the essential tenets of the fairness, equity, and due process. The denial of compromise the procedural integrity of the election process. My lord, at this stage, I am not pressing for anything, my lord. I just for your lordship may direct the deputy commissioner, which is pending before the deputy commissioner, but either disposing of or that I am not, even my lord, I am not obstructing the electoral process, nothing, my lord. Since my lord, one representation is pending, let the deputy commissioner may decide, my lord. Why the election commission so?
Yeah, that we can do. We can give a direction.
Yeah,
to the
I'm
commission.
not
Otherwise,
trying-
I'm not interfering in the
Yeah,
election
yes, my
process.
lord.
May
I am also not
make
praying
a
for
suggestion?
interfering in
If
the
your
election
lordship
process.
sees para 32 of the judgment that my learned friend has relied
No,
upon.
no, that I've seen. Lord.
Not for it is intervened in. Lord,
Okay.
if it is a part of a election process, my lord, the returning officer, who is the district officer, my lord, has no jurisdiction as of date of Tuomoto recalling that. But now any order passed by your lordship would amount to intervening into an election proceedings, my lord. And my lord, there is no other para 32.
My lord, I am relying. Wait a minute.
First
Para 32 clause.
My friend has relied upon para 32(3), but my friend has not read para 32(1).
No, that I've seen.
That's true,
If an
but
election-
these are conjoint, my lord.
If an election, the term election being widely interpreted so as to include all steps and entire proceedings commencing from the date of notification of election till the date of declaration of result is to be called in question, and which questioning may have the effect of interpreting, obstructing, or protracting the election proceedings in any manner, the invoking of judicial remedy has to be postponed till after the completing of proceedings in election.
Then para
So,
2,
my
my lord.
para 3 and all
Para
are in different contexts, my lords. That was a direction.
And
But
then,
once
my
it-
lord, para 3 also, my lord, any decision sought to render will not amount to calling in
If
question
all
of question and election. If the subserves the progress of the election and the facilitates completion of the election, anything done towards completing or in furtherance of the election proceedings cannot be described as questioning of the election. Subject to the above, that is important, man. Subject to the above, action taken or orders issued by the election are open to judicial review on the well settled parameters which enable judicial review of decision of statutory bodies, such as on a case of the Malafide and arbitrary exercise. Here in this case, they have rejected my case, my lord, on the ground of on the basis of a draft electoral rule, my lord. When my final electoral rule already issued by them, my lord, on 28/12/2024. Let the deputy commissioner see this, my lord.
Okay.
I am
My lord
nothing.
will see the
nothing else,
judgment
my
I
lord.
am relying upon, my lord, that Leela Sharma case, that 2019 1 GLT.
Who is that?
I just have. Yeah. The same provision interpreting, my lord, 3 issues were raised. If your lordship should kindly
These
come to.
three, I have preferred, one minute. I have preferred the 3 judgments, my lord.
2008, na?
Yes.
I will kindly come to para 20, my lord, of the judgment. Okay, sir. After hearing, has your lordship got, my lord? After hearing elaborate submissions on the learned counsel of the parties, following 3 issues arises for consideration in this batch of writ petition. What is the meaning of expression election? Whether rejection of nomination would fall within the ambit of the said expression election, whether in view of bar of under Article 243(o) of the Constitution and under Section 129(b) of the Panchayat Act, judicial review under Article 226 of the Constitution is totally excluded. What petitioner are entitled to the relief? Now, my lord, after deliberating, now your lordships kindly come to, after referring to many judgments of the apex court, my lord, your lordships at para 36. Therefore, from an analysis of the judicial pronouncements as above, there is no room for any doubt that the expression election, whether it appears under Article 324 or in Article 243(o) of the Constitution or under Section 129(b) of the Panchayat Act, has a wide connotation and would mean and cover every stage of the electoral process, commencing from the date of issuance of election notification till the date of declaration of results. So, my lord, in this case also, my lord, interpreting the same provision, this has, my lord, already been initiated. And para 47, my lord. Your lordship will also see, my lord, para 41, my lord. The issue relating to interference by high courts in election process under Article 220 continued to raise legal and constitutional issues after surveying the entire law on the subject. A 3-judge bench of the apex court in the case of Election Commission versus Ashok Kumar summed up the position.
You're reading from para?
41, my lord.
Okay.
The issue relating to interference by High Court in the election process under Article 226 of the Constitution continued to raise legal and constitutional questions after surveying the entire law on the subject. a three-judge bench of the Supreme Court in the case of Election Commission versus Ashok Kumar. My lord, this judgment is the same judgment which my learned friend is relying
Yes,
upon, my lord. That has been considered by your lordships. Versus summed up the position. Though entire conclusions may not be relevant for the purpose of the present adjudication, what is relevant to note is that the expression election has received wide interpretation so as to include all steps and entire proceedings commencing from the date of publication of notification of the election till the date of declaration of result. If an election is to be called in question, which questioning may have the effect of interpreting, obstructing, or protracting the election proceedings in any manner, invoking of judicial remedy has to be postponed till after the completion of the proceedings in election. Second legal position which has been called out is that any decision sought and rendered will not amount to calling in question an election if it subserves the progress of the election and facilitates completion of the election. So, my lord, this distinction has been made, my lord. Anything done towards completing or in furtherance of the election proceedings cannot be described as questioning the election. In the circumstances, action taken or orders issued by the Election Commission would be open to judicial review on the well-settled parameters such as mala fide or arbitration, exercise of power, or acting breach of law. Therefore, without interrupting, obstructing, or delaying the progress of the election proceedings, judicial intervention is available if assistance of the court is sought merely to correct or smoothen the progress of the election proceedings or remove obstacles. However, while doing so, courts must be very circumstanced and act with caution. Considering the very nature of the things, the court would act and reluctant and shall not act except on a clear and strong case for intervention having been made out by raising the pleas with particulars and precision and supporting the same by necessary materials. But after coming to all these judgments, my lords, para 45, my lord. Thus, from a careful conjoint analysis of the judgment to the Supreme Court as above, what comes to the fore is that ordinarily a challenge to an election has to be by way of election petition as provided under the statute. However, neither Article 329 or Article 243 would totally out judicial review from an electoral process. So also the provision of Section 129B of the Panchayat Act. If the decision of the returning officer or the election officer is found to be erroneous, which obstructs the democratic process or which creates hurdles in free flow of election, or which creates a situation where free and fair election is hampered, the High Court under Article 2 will certainly intervene and remedy of the situation to further the cause of electoral process. But also while doing so, the writ court would be extremely circumstanced and slow in invoking its power of judicial review. It is only when a full-fledged, foolproof case is made out in extraordinary circumstances the High Court would invoke its writ jurisdiction under Article 226 of the Constitution. Question number 2 is answered. Now, coming to all important issue dealt with by question number 3. Court is of the view that election as per the schedule is just round the corner. Today is 28th November, and that point of time. And the first phase of election is just 7 days away. Intervention by the writ court at this stage would cause manifold administrative problems for the State Election Commission. Besides creating confusion in the minds of electorate, the electorate must have a clear picture before them while exercising their right of it. Intervention by the court at this 11th hour would confuse the situation, which would be in interest of free and fair. As a matter of fact, a division bench of this court in writ appeal so-and-so dispose of so-and-so has taken a view that when the election process has been set in motion, court would not interfere in such measure by issuing direction. And that view of the matter, the court is not inclined to entertain writ petitions. How petitioner will have the remedy under Section 129B of Panchayat Act, which provides for filing of election petition within 60 days from the date of declaration of result. As noticed above, election results are scheduled to be declared on so-and-so. Petitioners may have availed their remedy under so-and-so within so-and-so. And if such election petition are filed, concerned Panchayat Election Tribunal precisely hear and decide the election will be necessary day to day. It may point out that under Section 86 of the Representation Act, every election petition is required to be tried as soon as possible, and endeavor should be made to conclude the trial within 6 months from the date on which election petition is presented. That being the position, the Panchayat Election Tribunals shall decide the election.
Where is this Panchayat Act?
Why not?
129.
If your lordship sees 129B. If your lordship is holding this book, page 137.
This same book?
Yes, perhaps, my lord. 129. Part 2 interference by courts in electoral matter. My lord will come to B. No election to any panchayat shall be called in question except by an election petition presented within 60 days from the date of declaration of election results to the tribunal constituted under section 127.
Okay.
In that case, one submission, my lord. My name is appeared in the final electoral.
That's a different issue.
No, only just, my lord, I have just.
That
given
you have
to-
remedy under 129B.
But so far as my question is that, my lord, if my
It's
name
the
is
same
appeared in.
thing that has happened in the previous case where today is what? 24th.
24.
Election is 2nd May.
Second
Correct?
of May.
2nd and 7th.
Yes.
Correct.
In the Kachar district, second of May, my lord.
2nd of, then
My only question is that, my lord, on ward number 8, my lord, my name is appeared in the final
maybe,
electoral.
maybe,
They
maybe.
have rejected my case in the ward number 7, my lord. Then
Correct.
where I have to cast my vote, my lord?
That
Being
you
the
have your
electoral,
own-
my lord,
that you have
where I have to
remedies.
cast the vote, my lord? My
Whatever it is, that is not the concern now. The issue is you're challenging your
nomination paper,
rejection of your nomination papers. Correct.
my lord.
That is the issue involved in this writ petition. That's all.
But only thing is that, my lord, my simple prayer is that, my lord, Deputy Commissioner may exercise his power and
That also would lead to obstruction.
And under what authority, my lord? He has no authority.
So it's your choice. You know my mind now. The court's mind.
in that case, your lordship may all merit, my lord, my case, my lord, dispose of, my lord.
Okay.
And in our High Court's judgment, my lord, in the last paragraph, my lord, there is also a dishonorable court, the being the
Which high
position.
court? Which judgment?
That is my learned friend had given, my lord, 2019 1 GLT 302.
Yeah, correct.
Last paragraph, my lord,
Hmm.
just while your lordship disposed of petition, my lord, the being the position panchayat election type shall decide the election petition of the petitioner. If filed as expeditiously as possible, if necessary, by holding day-to-day hearing, conclude the same within a period of 6 months from the that direction, your lordship may kindly, after election.
Then why don't you just withdraw and approach the election
Other-
commission by filing an election petition? Now you know
Petition is not-
you know what is going to happen.
At this stage, it's not possible, my lord, because, my lord, I'm approaching against the nomination.
Alam, I just don't understand. You want a rejection order at this stage?
In that case, your lordship pass appropriate order.
You want me to pass up with orders? I'll pass orders. Writ petition
But I am praying, I am
Yes. Dismiss.
only prayer is that, my lord, your lordship may direct the deputy district commissioner, since, my lord, she has been illegally rejected the nomination.
that
paper, my lord.
I'm not.
This is an extraordinary
Mr.
case, my
I
lord.
alarm learned counsel for the petitioner. Also heard Mr.
R. Dubey, my lord, for 2, 3, and 4.
R.
R. Dubey.
Gogoi for the respondents.
Dubey, my lord.
Dubey. R. Dubey. You're the standing council.
Yes, standing on state election.
Learned standing council, state election commission. For the respondents.
2, 3, and 4.
2, 3, and 4.
My friend appears for.
Mr.
I'm
Uh,
appealing for rest of the
K. Conwar, isn't that?
cake on
Learned
additional AG.
additional AG Assam for the respondents.
1, 4, 5, 6, and 7.
No.
Oh, 5 and 1, 5, 6, 7.
1, 5, 6, 7. Okay.
Deeply open.
Deeply obliged, my lord.
Two of Delhi list, admission.
Made clear. So this petition is directed as selling the inaction of the respondent APDCL in not providing uninterrupted power supply to the petitioner's three state mill. There are, my lord, various policies floated by the Ministry of Power, my lord, providing citizens will get power supply into 24/7 every year, my lord. Under those schemes, my lord, the 90% of the fund for I see, for installing the
The prayer is for installation of a dedicated feeder line, Malak, so for ensuring that they get a uninterrupted 24/7 power supply. Malak. That has been done, Malak. The line was set up on 2nd of December 2024 and then subsequently energized on 8th December 2020. Nothing remains, Malak.
Yes, anything survives.
my lord may kindly dispose of that they will provide uninterrupted
It
power
is
supply
already
in
been
view of the
provided.
installation of feeder, my lord.
They've already installed and the feeder is charged.
Yes.
So what more do you want?
Your lordship may kindly dispose of with
Okay.
the
Heard, Mr.
SK Kejriwal.
SK
SK.
Kejriwal, Learned Counsel for Petition. Also heard Mr.
P. Chaudhary, Malak.
P. Chowdhury, Learned Standing Counsel,
APDCL, Malak. for-
ABDCL. Stop. Para. The petitioner is a duly incorporated company under the Companies Act 1956, having its registered office at Continental Chambers, 4th floor, 15A Himanda Basu Sarani, Kolkata. The petitioner company carries on the business inter alia of plantation, manufacture and sale of black tea. And for that purpose, they own the Ratan, Rat, Ratanpuri, Ratanpur tea estate at Pio Nunapani in the district of Kachar, Assam. Stop. It is the case of the petitioner that since the date of inception, the petitioner company could not run its industry efficiently due to erratic power supply. Inasmuch as there is frequent and long power cuts without any prior notice. Stop. The petitioner company therefore has approached this court by way of the present petition with the following prayers, page 22, A to A. Okay. Para. Mr. P. Chowdhury, Learned Standing Counsel, ABDCL, has produced a communication dated 23/4/2025. Which one is the main communication?
The first one. Let me refer to the first.
Written by the Assistant General Manager, Silchar Electrical Division -1, ABDCL, CAR, Silchar, and addressed to the Chief Executive Officer, Kachar Electrical Circle, ABDCL, CAR, Meherpur. And the said communication is extracted here and below. B to B. Para. Considering the contents of the communication dated 23/4/2025. This court is of the considered opinion that the grievance of the petitioners has been redressed. Stop. Learned counsel for the petitioner also submits that as the grievance of the petitioner has been redressed by the communication dated 23/4/2025, this writ petition may be closed. Correct? Stop. Para. Recording the submission made by the learned counsel for the petitioner and also taking into consideration the communication dated 23/4/2025, extracted here and above, comma, this writ petition is accordingly closed. The communication dated 23/4/2025 is placed on the court.
Thank you.
3, 4, and 5.
Before my learning senior starts, I'd like to apologize before your lordship as well as the senior counsel. Lordship, the main arguing counsel is on legs in another court. Can this matter be taken up to some time? Just
After
for a
some
few
time,
minutes.
Mr. Gogoi will be arguing, he said. So
Lordship,
after some time, it will.
just for a few minutes. Much better.
6,
Lordship, my senior is in legs in virtual court. May the matter be taken up for time being.
What is it?
Virtual court.
Virtual court.
Yes, Lordship. My senior legs in virtual
Yes.
court. Lordship, after some time then.
Okay. Who's your senior?
Mr. BK Singh.
Okay.
7,
Mid page, Lordship. This is relating to my lord subsidy.
Subsidy.
Relating to, the case is relating to subsidy, my lord. And your lordship has heard to some extent that the petitioner applied for some subsidy as my lord announced by the Ministry of Food Processing. Thereafter, my lord, within the stipulated time, my lord, they have applied, but my lord, after application, the GM has, my lord, processed the file and recommended certain amount and my lord sent to the commissioner office. And the file was gathering dust. It was never processed, not my lord placed before the SLC. Then he approached this court earlier. Thereafter, my lord, something has happened and my lord, now I'm placing the facts. My lord. Thereafter is this.
Lordship, last
Yes, sir.
occasion, Lordship, this matter was
Partly
heard.
heard.
It matter
Yes.
was heard. It was heard at length. Only issue was there. The lordship wanted to look into the records. The records are with me. Whether the application was filed in time or not, or whether the application was complete or not. That was the issue remain, lordship. Nothing else to be argued here. So only thing is that the record has to
I'm
be seen.
refreshing, my lord. because
Record
it's a
has to
long
be
time.
seen and like
Around
that has to be filed.
1.5 month, I thought. More than 1 month. I think.
Yeah, Kalita, just a little,
Yes, ma'am.
don't expand too much. You are.
Yes, my lord. Then, my lord, I have prepared written argument and thereafter, my lord, just I'm reading the imprint order now. Imprint order.
Who is that order?
That order is at page.
Where was the first writ petition filed?
First writ petition was filed in 2017, my lord. The order is at my lord. Annexure 9,
Page
page 48.
49, isn't
Page
it?
48, yes, my lord.
Page
Page
49.
49 onwards.
Ah.
The first writ petition was decided in favor of the petitioner. And my lord, relevant paragraph I am reading, my lord. That is the page 54, my lord. Page 54, paragraph 13, only 3 paragraphs I am reading. Since the petitioner is aggrieved by non-consideration of its application for granting aid by the appropriate committee.
No, that's not para 15.
Para 15, yes, ma'am. It is made clear that if an examination of the representation submitted by the petitioner, the departmental authorities are of the view that the application submitted by the petitioner was a genuine one and the same was complete in all respect and was also submitted within the period of validity of the scheme in question. In that event, appropriate steps may be taken for redressal of grievances of the petitioner as may be possible permissible under the law, whatsoever addition and so on. Here for paragraph 14 is necessary, my lord. For the reasons noted herein above, I am of the view that the application submitted by the writ petitioner seeking financial assistance deserves to be considered on merit by the appropriate authority. As such, this writ petition is being disposed of by providing that within 4 weeks from today, the writ petitioner may submit a detailed representation enclosing a certified copy of the address and so forth, continuing its grievances in the matter. So accordingly, I have filed.
So
Yes.
there were three conditions that this court gave in
Yes.
paragraph 7, paragraph 15. That if your application was number one, genuine.
Yes.
And number two was complete in all respects, you
Yes.
know, and then it was submitted within the validity period,
Yes,
within the validity period of the scheme,
exactly.
correct?
Yes,
So these three they have to consider.
yes.
Then what
They
happens
have,
after that?
they have passed an impugn order that is at page 65, my lord. An accepted page 65. Just a moment.
Okay.
Yes. From the last but one paragraph, my lord. Whereas during scrutiny of the documents, your lordship may kindly see. Third paragraph, fourth paragraph from the below, my lord. Whereas during scrutiny of the documents submitted along with the proposal of Messrs. So and so, the following observations were made. The industrial unit under reference is an existing one undergoing expansion for the same reason. A thorough scrutiny of the documents of the machineries existed thereon prior to expansion of machineries proposed for after expansion was required to be done by way of both field verification and cross-checking documents with bill vouchers. There was also requirement of verifying the payment of documents of machineries and other eligible components of the proposal which were purchased through bank, related bank, check numbers, demand of so and so, so and so, so and so. As per clause so and so, guidelines of notary, non-judicial stamp paper, so and so. Whether the organization sister concern has all these are given, my lord, where the unit had informed by an affidavit by so and so, that and so and so, all these things. Hereafter, your lordship may kindly come to the next page, page 67, my lord. That is important. Whereas Ministry of Food Processing Industry, Government of India, by its letter number so and so, 2017-2015, had clarified that no Government of India funds would be available for implementation of NFEP by the states from financial year 2015 and 16 and onwards in view of the delinking of NFEP from financial support of the Government of India. In the same matter, the Ministry of Food Processing Industries, Government of India had also mentioned that since the mission has been dealing for financial assistance of Government of India from the year 2015-16, the Government of Assam was requested to ensure funds to all the ongoing projects approved by the SLC, including the committed liabilities from the state resources, with a request to the state government to take a decision regarding implementation of so-and-so or otherwise on so-and-so and onwards. Here, my lord, that means ongoing projects. That has been, my lord, before 1st of April 2015, whatever applications were filed, that will be processed. My application was filed in, my lord, 2014. Thereafter, my lord, the GM has, my lord, he has visited the unit, scrutiny all the documents, and his recommendation was sent, my lord, to the commissioner office. But, my lord, instead of, my lord, placing the file before the SLC or, my lord, scrutiny of the file, they remain. Thereafter, my person was, my lord, they were pursuing the pursuing the office, then only verbally they told to finance. Recommendation was, my lord, at page 43. It was on 29 March 2014 by the General Manager District. So it was an ongoing and, my lord, under process file. Page 43.
Yes.
The GM has forwarded to the State Mission Director, National Mission for Food Processing. Documents below. Thereafter, my lord, the finance, my lord, this scheme was stopped, my lord, 1st April 2015 onwards. But, my lord, finance will be given to, my lord, 31st March 2016 because of the ongoing or under process file. So, my lord, my file was undergoing. It was under process, half, my lord, left. And, my lord, the finance was available till 31st of 2016, 31st March of 2016, because financial year is 15 and 16. Then I'm reading again more, my lord, that whereas the then Industries, Commerce and Release all outstanding committee liabilities so and so, state budget against them, which were approved by the competent committee in accordance with so and so. Their allegation is that, my lord, that I have filed certain documents on, my lord, is found there affidavit on, my lord, 2015, 16 April, I think, 16 April, 16 April 2015. Then also it is very much, my lord, within the time, because there is no communication, not a single letter to the GM, not a single letter to the party concerned that you submit so and so documents. Normally, all offices which further, my lord, requires any more documents, they write a letter to the authority, to the petitioner or to the applicant who has applied for anything, my lord. The government office writes to the, my lord, applicant that these are the documents you should submit. But there is not a single letter or any communication to the GM office, who is the local office, nor to the, my lord, petitioner. But, my lord, on their pursuance of the file, then only they said, oh, you filed these documents. Then, my lord, after a long time of, my lord, filing the file, filing the application, they told, and accordingly, immediately they have filed this, my lord, on affidavit notary. That actually requires another judgment time filing. That only requires after the SLC approve the fund. Then, my lord, the security bond and affidavit is required. Not prior to that. So they have never placed before the SLC meeting. My file was not placed in the SLC meeting. The case. So here, little bit. Again, I'm reading page 67, my lord. Page 67, last paragraph. Whereas Government of Assam by so and so planning development in the union budget so and so announcement, it was found that several schemes were discounted, budgetary allocation, some schemes was reduced, and so and so. National Central Assistance, including national mission food processing, have been dealing from the union support, and in view of the above and to ensure fiscal discipline, the procedure for grant of administrative approval, financial sanction and release of fund and the different components of the annual plan has been reviewed, and henceforth it will be governed by the procedure as one. But here, my lord, the after the first court order, it is written, my lord, that for financial, he has written, my lord, one letter I'm placing, lordship, my lord, but it was rejected. Let me place it first, my lord, that page 69, only this giving reasons, my lord, where in pursuance of the order of the Honorable High Court and considering all the above facts and circumstances, the Industries, Commerce and Public Enterprise Department, Government of Assam finds no reasonable ground to consider the application of Messrs. So and so for availing incentives under the NFPP scheme. But whereas the another year was left, my lord, till 31st of March 2016, another year was left after filing of the documents. They should have processed my file and approved it. They have never placed before the SLC. Only after I have approached this court, they are taking this time. On the other hand, my lord, the director of my lord AIDC, he has forwarded one letter, my lord. That my lord, yes, my lord, it is in page 64, my lord. Managing Director of AIDC. He was the page 64. Here it was written, my lord, with references of the Secretary of the honor to submit here with a detailed note along with supporting. He has written this to the, my lord, Under Secretary, Ministry of Food Processing Industries, Government of India. On 24th of February 2023, giving reference Honorable High Court order dated so and so. With reference to the subject matter, I have the honor to submit here with a detailed note along with supporting documents on the proposal submitted by so and so, availing granting and after so and so. It is regarded to this mention here that the NFP scheme was dealing for financial assistance from central government for so and so, Ministry of MOPI, addressed to Chief Secretary Assam. Additionally, it was mentioned in the letter, since the mission has been dealing for financial operations, you are requested to ensure release of funds to all ongoing projects approved by LCC, including the committed liabilities from state's resources. Further, state government is also requested to take decision for implementing of the scheme of so and so or otherwise so and so. Additionally, dear letter so and so, Chief Secretary committed. Accordingly, next paragraph. Accordingly, Industrial and Commerce Department, Government of Assam, has made budgetary provision under the scheme for an amount of rupees 100 crore in the year 2016-17 and rupees 900 so and so in the year 2017-18. It was paid up to 17-18 to clear the total committed liabilities. It is important, my lord. Kindly see scheme for an amount of so and so in the year 2016-17 and so for another 2 years in the year so 2018 to clear the total committed liabilities amounting to so and so against the proposals approved by and disbursed to the unit. Subsequently, government of some so and so had decided that so and so all those schemes which are in the state budget so and so but not in the union budget so and so will be given by the administrative department so and so so and so. In this regard, it is also to be mentioned that there was no mention in the letter so and so July 2015 about the set of proposals under the scheme who had applied within the time period of the validity of the scheme but could not be processed further the application due to further scrutiny, etc. In view of the above, I would like to request you kindly to make necessary arrangements. For compliance of the Honorable Guwahati High Court order, Code of so wherein the Government of India, Union of India, Ministry of Food Processing Industries, Government of India was also one of the defendants and referred case which was notified by so and so. So, my lord, it reflects up to 2018 they are paying. Different funds were, my lord, allotted and sanctioned. Then my proposals are why he has been giving all the documents in 2015 April itself. Earlier document they have submitted. The further document that, my lord, that one affidavit and, my lord, that surety bond, that was only left. That was taken in, my lord, April 2015. So why they are, my lord, delaying and neglecting the project? It is solely the officers engaged there are solely responsible for, my lord, non-approval of my project. So in the records, what we show. This is the main gist of the case. Now I am placing, my lord, one written argument I have prepared, my lord. And some important cases I would like to place. A written argument I will copy to do. মার্ক করা হয়তো মার্ক করা হল কোন মার্ক করা আর এখন দিছা আরেকখন দিছা এখন মার্ক করা হল না নকরা হল দিদিলা কে তিন আর্গুমেন্ট এখন ইয়াতে করে দিন নাকি
You can read. Yes.
Only, my lord, I'm not reading the facts. I'm reading the submission made. Page 2, your lordship may kindly see. That is why the speaking order is bad, my lord. That the speaking order of the commissioner dated so and so is bad in law for the following reasons.
No, that I will go through. That I will
Yes,
go through.
ma'am.
There's no problem.
So the
What is
direction
this?
given
Oh, judgments.
judgments. One thing, my lord, that direction was given by this court, my lord, to the additional secretary who was in charge of industries. But, my lord, the commissioner of industries has disposed of the writ petition, my lord, without application, my lord, representation, and without going, my lord, to the facts of the case. So, my lord, your lordship may kindly see the reason given, my lord, here. Here, my lord, only one paragraph reading. As mentioned in the speaking order, the scheme was discontinued with effect from 1/4/2015. Whereas Government of India provided fund for all the ongoing projects for the financial year 2015-16, that the financial assistance from Government of India was provided for the year 2015-16. That means till 31st March of 2016. But from the letter of the, my lord, Managing Director AIDC, it is seen, my lord, till 2018. 17-18, the funds were, my lord, allotted, and it was disbursed on the ongoing or, my lord, pending projects, which were, my lord, in the valid period, my lord, the application was filed. And regarding the decision, my lord, just I'll not read, my lord, mark the paragraph. In the first decision, your lordship may kindly see paragraph page, my lord. The very famous judgment, which has subsequently also, my lord, confirmed. It is in page 39. Your lordship may kindly mark it only, my lord. Page 39, last paragraph. If this is the kind of detriment complemented, it would necessarily be present in every case, promise or estoppel, because it is on account of such detriment which the promise would suffer if the promissory were to act differently from his promise, that the court would consider it inequitable to allow the promissory to go back upon his promise. It would therefore be correct to show that in order to invoke a doctrine of promissory estoppel, it is enough to show that the promissory has acting to reliance on the promise altered his position, and it is not necessary for him to further show that he has acted to his detriment. Here, the appellant clearly altered its position by borrowing monies from various financial institutions, purchasing plant and machinery from so-and-so, and setting up a Vanaspati plant. In the brief induced by the representation by the government had sale tax exemption so-and-so, so-and-so. The government was therefore bound on the principle of promissory estoppel to make good the representation made by it. You will kindly read the whole paragraph. So, my lord, in this present case also, my lord, the on the promise of the authority, my lord, they have set up this, expanded this plant, buying new machineries, taking loan from the bank and our various financial institutions. So he has altered his position, and in that case, government cannot go back, my lord, and neglect the promise. They are bound to, my lord, fill the promise. So, my lord, although the, my lord, scheme was withdrawn, but it was filed during the validity period, and partly it was processed, and, my lord, it was recommended by the local officer, my lord, that is GM Industries. In the next case, my lord, your lordship kindly see if you only paragraph 8, page 45, my lord, page 45. Page 45, yes. The schemes floated by the state releasing grant of subsidy for industrial unit to be set up in certain selected backward districts areas have a benevolent and public purpose to achieve, and that is to promote the growth of industries in such district areas which but for the state encouragement would continue to remain backward and the industrial investment will not be attracted to such areas. Northeast is a very backward area, Lordship, will admit that. Such schemes have to be construed with practical and pragmatic approach so as to achieve and not frustrate the purpose sought to be achieved. The benefit of the scheme ought to be allowed if it can be done. The application should not be dealt with a hypothetical approach or in a pedantic manner. If the application filed before the cutoff date is substantially in order and satisfies the formalities expected of the scheme, then an opportunity should be allowed to the applicant to cure the defects which are not of substantial nature or are capable of being cured so that the deserving units are not left out of the scheme. Exactly cover my case, my lord, your lordship. Page 49, it is enough, my lord, it's a very long judgment. Held, my lord. Page 49, held. And read paragraph 11 and 10, my lord. Here also, my lord, if the state or statutory authority or an executive authority of another state on behalf of the state exercise legally permissible powers and then
Page
permits.
49.
Page 49. Paragraph 11 and 10 has to be read, my lord. I'm just sorting it out, my lord. That thing the promisor or is quasi-relation with the power inhering the promisor or is not otherwise opposed to public policy.
Reading
Then-
from where?
From the held. From paragraph 10 is that, my lord. Paragraph 10 and 11 has to be read. That is at page. Lordship will note down paragraph 10 and 11. Although I have in the list type the paragraph also. That is at page 59. Also same, my lord. Their power tariff was reduced, then again, my lord, a little bit long. It is now well settled a series of decisions of this court that the state authorities as well as the limbs like the board covered by the sweep of Article 12 of the Constitution of India being treated as state within the meaning of the said article can be made subject to equitable doctrine of promissory estoppel in cases where because of their representation the party claiming estoppel has changed its position. And if such an appeal does not fly in the face of any statutory provision, prohibition, absence of power and authority of the promisor and is otherwise not opposed to public interest, and also when equity in favor of the promisee does not outweigh equity in favor of the promisor, entitling the latter to legally get out of the promise. In this connection, yes, my lord, they are regarding promissory estoppel, they have, my lord, discussed all this foreign laws also. As line, my lord, as on the principle of promissory estoppel, the promisor can be pinned. Page 61, top line, my lord. Then on the principle of promissory estoppel, the promisor can be pinned down to the promise offered by it by way of top line page 61. Only one line I'm reading here from here. It is the paragraph 11, last line. Then on the principle of promissory estoppel, the promisor can be pinned down to the promise offered by it by way of representation containing such promise for the benefit of the promise. Here, my lord, the electrical tariff was raised, then my lord, promise was made, it will be reduced, then again cancelled. Therefore, my lord, against the electricity board, that is been decided. Then, my lord, page 94, my lord. Yes, ma'am. Page 94, another Mahabir Vegetables Oils Private Limited and another. Here also, my lord. Paragraph 25, that is at page 103, page 103, relevant paragraph. It is beyond any cavil that the doctrine of promissory estoppel operates even in the legislative field, whereas in England, the development and growth of promissory estoppel can be traced from Central London Property Trust Limited versus High Trees House Limited. In India, the same can be traced from the decision of this court in Collector of Bombay versus Municipal Corporation of the City Bombay. In that case, the government made a grant of land which did not fulfill requisite statutory formalities rent-free. It, however, claimed rent after 70 years. The government, it was opined, could not do so as they were estopped. It was further held therein that there was no overriding public interest which would make it inequitable to enforce estoppel against the state, as it was well within the power of the state to grant such exemption. Next, paragraph 26, the Motilam Padampat, which I have read in the first one, that was discussed, my lord, and support. Confirm. Then, my lord, our High Court judgment, my lord, 108, page 108, Union of India versus Vision Ispat. Here all appeals were, petitions were allowed. Then, my lord, they filed appeal, and thereafter, my lord, division bench was confirmed. Page 115, paragraph 22. In the cases before us also, we have ascertained that the uncontroversial findings made by the learned single judge give rise to a fact situation for application of the doctrine of promissory estoppel in favor of the petitioners in the writ petitions and as against the respondents' appellants. The petitioners in the writ petitions who acted in pursuance of the promise of the said authorities and incurred expenditure cannot be deprived of the benefits under the said scheme simply by taking the plea that the scheme has been withdrawn subsequently. The said withdrawal cannot be made in violation of the doctrine of promissory estoppel. The submission made by the learned CJSC in this regard is not accepted. So, my lord, here, my lord, learned single judge allowed the writ petition. They went for appeal. This case went for, my lord, in Supreme Court also, and they have dismissed in limine, not even admitted. The Union of India, they approached the Supreme Court also, and this Honorable Supreme Court did not even admit the case. Next, my lord, here again, my lord, our High Court case, page 116. It is a very long case and discuss everything regarding COT bond and everything, affidavit. All has been discussed. But if your lordship granting it, so it's there. Mr. Kolita was also there. These petitions were allowed by the learned single judge. Then, my lord, it was confirmed by division bench also. Same point, my lord. Thereafter, regarding interest, my lord, page 133, this J. Tarian case, Union of India against the learned single judge, Union of India appealed before the division bench, my lord, upheld the single bench order. Hereafter, they have, my lord, appealed before the Honorable Supreme Court. Still, it is pending there. Because it was also long pending case, my lord, since 2014. Now, my lord, more than, it is 11 years running now, my lord. They are deprived, they should have get it by 16. One thing, my lord, that in the written argument, one typing mistake is there, my lord. They have approached the Supreme Court. Here it is written, my lord. They have. That has to be corrected, my lord. With your lordship permission, I will be allowed.
Your written argument is upside down.
of petition.
Correct it.
Yes, বেলা এখন দিয়া petition. এখন কারেক্ট করে দিয়া এই এখন কারেক্ট করে দিয়া এবার এখন কারেক্ট করে prepare long back development server avail the addition of the no further activity it will lost now itu now ko dia hal itu tadi now ko dia W. This is my, so your lordship will go to the record, my lord, whether any communication was made for my lord asking for any documents. And no letter to the GM also. Dila, ঠিকে আছে নে? এইখনকে নিদিবা, বেলেগ এখন নিদিয়া কি? ভুলকে দিছা নেকি? কলিতে তোমাক এখন দিয়াচোন। এখন মই ৰঙা দিলে পিটি দিম। এখন দিলে, ঠিক আছে নে? I'm making it as short as possible, my lord.
Yeah, we've heard it before.
Yes, ma'am.
You have the records.
I have the record, but before I place the records, there's two, three things, I'll just clarify. First, lordship, this letter, like he was pointing about this letter, which is at page 64 of the writ petition.
Oh, yes.
So lordship, I have page 64.
Yes.
So lordship, I have already pointed out last time that this is a central government scheme basically. And it was like 90% and 10%. The state's liability is only 10% and 90% by the central government. Now in 2015, in the April, they have delinked it and they have left it to the state government whether they wanted to continue or not. So state government has decided that they will not continue with the scheme. So it's stopped there. But only thing remain is that there are some liabilities have been created because there were some applicants who have in fact.
1 minute, it was delinked in 2015.
Not it?
It was
Yes, Lord. Yes, it was delinked in the 1st of April 2015.
State government decided not to.
Not to continue it because state government doesn't have that much of fund because it was 90%, 10%. Ratio was 90-10.
Now it will be 100.
Yes, so it would be 100. So state government decided not to go ahead with this scheme. The only thing remained is that like what happens to those applications, the applications received from the units that they have actually altered the positions, whatever, under the scheme, and what will happen to their liabilities. So that is why, let's say, this letter was written. Earlier also there were some communications, and this letter was written about the funding. So like there were a lot of applicants whose applications have been approved by the SLEs. So their applications have been already approved. So the liability has been created. So state government wanted that those liabilities should be cleared.
Yes.
So accordingly, state government had allotted certain funds and those liabilities have been cleared. Those units whose applications have been approved by the SLEC, those have been cleared.
Okay.
After the withdrawal of the scheme also.
Is it SLEC or SLC?
SLEC, it's an empowered committee, state level empowered committee.
Yes.
So this letter has been written in that context. So this letter doesn't have any relevance to this particular case. This is my submission as far as this letter is concerned. Now, Lordship, I'll take your Lordship to that impugn speaking order. It makes everything clear, Lordship. That is at page 65. I'll take a little bit of time. I'll just read out Lordship.
Okay, just 5 minutes.
Yes. So Lordship, it was post this High Court's direction. So where is the representation dated so and so addressed to Additional Chief Secretary? This Lordship can escape. And whereas the Viva Vikas applied for availing incentives under National Mission on Food Processing for the remainder period of 12 plan, 2013, 14, 16, 17, for the component under the expansion scheme for their project, wherein they applied for scheme technology upgradation, establishment, modernization of food processing industries as mentioned in clause 7.11 of scheme guideline published by the Ministry of Food Processing Industries, Government of India for expansion of their existing unit located at Malini Bill so and so. Now Lordship can escape this page, then Lordship can come to page 66. Whereas the unit had informed by an affidavit dated so and so that an amount of rupees 49.50 lakh as financial assistance for setting up this unit in the past was received by from Ministry of Food Processing by sanctioned letter number so and so dated 25th April 2012. For this further requirement of verification of documents were needed to ascertain admissible amount of NMFP assistance grant excluding the amount already received. Whereas though the proposal was submitted within the validity of the scheme, there is no Lordship dispute in that scheme. The application was not complete in all respect. The following documents were not submitted along with their application, which was informed to the unit on several occasions via telephonic calls. First one is Lordship duly notarized surety bond executed by the beneficiary company on non-judicial stamp paper of not less than ₹100. Chartered accountant certificate so and so. Whereas during the process of verification, it was found that the following documents were submitted by the petitioner along with a forwarding letter without mentioning any dates. The documents submitted were as follows: a surety bond without mentioning any date of signing. However, the same was notarized and signed on 16/4/2015. So it is post-dealing, post-dealing. 16/4/2015. A certificate dated 16/4/2015 from Chartered Accountant certifying the investments made by the petitioner from for expansion cum modernization. A list of unsecured loans dated 16/4/2015 certified by the Chartered Accountants of the petitioner. A certificate without any date issued by the Punjab National Bank certifying the release of rupees 150 lakhs to the petitioner, Mrs. Viva Vikas. Whereas it is clear from the above mentioned documents that though the petitioner had submitted the application for granting aid under so and so on 26/3/2014, many of the required documents were submitted very late, that is on 16/4/2015. Therefore, though the authorities processed the application of the petitioner, same could not be placed before the competent committee for consideration. So this is the issue, Lords. By the time the Ministry of Food Processing Industries, Government of India, delinked the scheme from Union Budget with effect from 1st April 2015 by letter number so and so. Now this paragraph, Lordship, this paragraph was read by my learned friend. Whereas the Ministry of Food Processing Industry, Government of India, by letter dated so and so, had clarified that no Government of India funds would be available for implementation of NMFP by the states from financial year 2015-16 and onwards in view of the delinking of NMFP from financial support of the Government of India. In the same letter, Ministry of Food Processing Industries, Government of India had also mentioned that since the mission had been delinked for financial assistance of Government of India from the year 2015-16, the Government of Assam was requested to ensure funds to all ongoing projects approved. This word approved was not properly read, Lordship. So ongoing projects approved by the SLEC, State Level Empowered Committee, including the committed liabilities from the state resources with a request to the state government to take a decision regarding implementation of NMFP scheme or otherwise with effect from 1/4/2015 onwards. So this is the issue, Lordship. Only those applications which have been already approved by the SLEC, we are liable to pay. Now, whereas then the Industry and Commerce Department had released all outstanding committed liabilities amounting to rupees 10 crores 65 lakhs 15,954 only from the state budget against the proposals which were approved by the competent committee in accordance with the Government of India letter dated 27/3/2015. So we have cleared all the liabilities, Lordship, where liabilities have been created. We have cleared all those liabilities. Whereas the processing of the proposal under reference was not complete for late submission of the required documents by the applicant and so and so, hence no committed liability was created against the proposal under the scheme. Therefore, the proposal was not in a position to place before the SLC constituted for the purpose as per guidelines of NMFP. Reference may be made to DO letter number so and so, so and so. So this is the case, Lordship. Now, Lordship, next page 68. Third paragraph, Lordship. Whereas in view of the above, as there was no budgetary provision under the scheme NMFP in Union Budget 2015-16, the scheme was not considered for continuation in accordance with the OM number so and so dated 17 August 2015. A decision has been taken that the scheme will not be continued by the state government. Whereas neither the DO letter number so and so dated 27 March 2015 from MFPI informing discontinuation of NMFP scheme from Union Budget with effect from 2015-16, nor the report of the committee constituted by so and so dated 19 October 2016 with Sri KV Epan, IAS Additional Chief Secretary to Government of India, so and so department as the chairperson, recommended payment of financial assistance under NMFP against those proposals which were under process but not approved by respective empowered committee. So decision has been taken, Lordship, those applications which were under process, which have been filed but not approved by the SLC will not be considered. That's a decision has been taken by the government, Lordship. And accordingly, Lordship, this application, since it was not complete application, so that is why it was not placed before the SLC at that point of time when the scheme was active. Now, when the scheme has gone, there was no occasion to place it before the SLC. The SLC is already defunct. So that is the case, Lordship. Now, Lordship, couple of more things. As far as Lordship, applications, their application, Lordship, that record is there with me. I'll show the record. I'll place it before your Lordship. I flag marked this. All the flag marks also, I'll just point out to all those flag marks. The Lordship wanted to see the record because whether this application was filed in time, whether the records were complete, or their application was complete or not. So Lordship, my bill submission is an application which is not complete with required documents. Is not an application at all. So since this application was not complete, that's why it was not placed before the SLEC. So Lordship may kindly refer to page 191. That is flag mark. First flag mark. The Lordship will see there, though the affidavit has been filed, there is no date there. There is no date of signing as to when this affidavit was signed. Though there is a notary there.
Yes.
Though there is a notary. No, there is a notary date. It is not a signing date. There's a difference between notarized date and like signing date. You should be aware of this. You should be aware of this, that signing date and notary date are two different dates.
The advocates prepared the affidavit. It is his fault, my lord, not my client's fault. Advocate prepared the affidavit. He should have given date. Otherwise, how can affidavit can be notarized?
Anyway,
then Lordship will find
notary date is 28/3/2014.
Yes.
Yes.
It's correct. That was there. Then Lordship will find.
Advocate is prepared.
Let
He
me
is not prepared. This cannot be.
Advocate has prepared on behalf of whom?
Whom is he's a layman. The business means.
I don't want to argue, I don't want to argue on that.
Writing on affidavit.
I don't want to argue on that.
Yes.
Page 192, Lordship will find the security bond. Lordship will find that security bond also, Lordship, there are the blanks there. Those are not filled up. And Lordship will find that last page of the security bond. Lordship will, Lordship may kindly,
Undertaking.
Lordship may kindly peruse that, that witness part, Lordship. There are two witnesses are required, Lordship. So one witness is the applicant himself.
Which one?
The second one, Lordship.
Raja Bani.
Yes, he is the applicant himself. So he can't be a witness there. He himself can't be a witness. The two witnesses were required, those were not there. That is why, Lordship, those were the reasons those documents were sought again.
Somnath Bani. Is Modern Mohan. Just I want to know.
Okay.
The 209 page, Lordship, there is a note there, Lordship. They were saying that like, there was no communications from the side of the department. The 209, Lordship, may kindly peruse. That document is not with me. That is there on the record. So there's a team which visited at a site prior to the expiry of the scheme, and they have reported that there are certain documents were not there, and those documents have to be submitted, and accordingly they have resubmitted those documents. There's a list there, Lordship.
See, this surety bond, what you're saying is notarized date 16/4/2015.
That is that they have submitted later on. Another security bond they have submitted.
here.
Yeah, it's there.
Okay. So the first one was not submitted.
The first one was there submitted, but like those witnesses is not there. There were some blanks were there. So that's why they have resubmitted those security bonds.
Okay.
The next page, Lordship, 2000, Lordship, 211. Lordship, may come to 211. That's the security bond.
What 2010 is what?
2010, Lordship, I don't know what was
This is
there.
a letter to the State Mission Director.
That is maybe a forwarding letter, Lord.
Okay, here also no date.
Yeah, there is no date. It's a forwarding letter. There is no date, Lord. Then this security bond, 2000 to page 211. So Lordship will find that security bond was submitted on 16/4/2015. But there is no signed date, but from the notary, we can find out that it was filed on 16/4/2015.
Yeah, the witness has been changed.
Yeah, witness has been changed because there was a fault there earlier. Because he himself signed in the witness column. Now, Lordship, the security bond, Lordship has seen that it was filed on 16/4/2015. It is post delinking of the scheme. Now, Lordship, 214, Lordship, will say, is a CA report that was also not dated, but it was probably on 16/4/2015. Post delinking. Correct, Lordship. Then, Lordship, 216 says 216. That was also a required document. That is PN bank certificate. Bank certificate is not dated. So those are the records Lordship wanted to see, and like Lordship, I have placed it, and from those records, it is very clear that they have not submitted that their application with all the documents earlier when they submitted in 2014. But subsequently in 2015, they have submitted those documents, which is post delinking of the scheme, and SLAC was not in a position to consider their application. And that was the
Whether
issue.
it was placed before the SLC.
That was the SLC was defunct because this was delinked and state government decided not to go ahead with the scheme. That is Lordship has already seen that.
Where's that memorandum where the state government decided?
That has been Lordship, that is there in the, I mean, that memorandum is not there with me, but they have written in their speaking order very clearly.
That's fine.
That's, they have written it very clearly, because they didn't want to go ahead with this. That is not disputed, Lordship. That is not a disputed question at all. Now, Lordship, as far as promissory estoppel is concerned, see, as far as Lordship factual stuff is concerned, Lordship is clear probably. These documents were submitted post delinking of the scheme, and that is why it could not be placed before the SLEC. And Lordship has seen that that budget has been given by the central government only for these things where SLEC has already approved. So liability has been created, and all those approved applications have been cleared by the state government already. Payments have been made.
Do you have a note sheet along with this records?
There is a note sheet, Lordship. Let's say this. But this may not have all those notings, Lordship. I've seen that. Those notings are not. Only relevant thing I could find, that note, Lordship, that green note, Lordship, is seen. I have flag mark. That is the only note I have seen. No, not there, Lordship, in the file. This is a very old file, Lordship. Maybe all notes are not there also. I'm not very sure. So, Lordship, as far as the completion of the document and application, which date will be counted? So, Delhi High Court has passed the judgment here. I'll just place it before your Lordship. So here, Lordship, the issue was obviously different. Here, Lordship, there is Section 34 application. The application was filed without not many relevant documents. So they have sought for continuation of delay. Now the issue was that whether the initial filing of the application and the curation of the defect by submitting those relevant documents, which date will be taken into account? Because when this application is complete, that was the issue. So here the Lordship will find a paragraph from paragraph 12 onwards, Lordship. May I read out, Lordship, from paragraph 12? In view of the above, the only question to be determined is whether initial filing date was valid. As noted above, the initial filing was only 73 pages. The petition was not accompanied by a copy of the award or any other document. It was also not accompanied by a statement of truth, which is mandatorily required. As noted above, the petition as subsequently filed on 24/10/2019 spanned over 1,325 pages, including documents. It is thus apparent that entire framework of the petition was changed. There is merit in respondent's contention that petition as filed on 24/10/2019 cannot be considered as the same petition that was filed on 13/9/2019. It is also material to note that petition as filed on 13/9/2019 was not accompanied by the impugned award or the wakalatnama. The decision of the coordinate bench of this court in so and so is squarely applicable to in these facts of the case, and therefore the filing as on 13/9/2019 cannot be considered as a valid filing. in the circumstances 24/10/19 is required to be considered as a first date of filing of the present petition. The delay in filing so is concerned. So lordship, the filing date, which is when the document is complete, when the applicant is fully complete, that has to be taken into account. So earlier filing date, if you have filed an application without giving those material documents, that date of filing will not be considered as date of filing. So date of filing will be when you complete the whole bunch of like submitting whole bunch of document and the application is complete. So this is my submission on this, lordship. So in this case, lordship, their application was not complete. Their application was not an application at all. It cannot be taken as a termed as an application because it was not complete with the documents. When they have filed those applications on 16/4/2015, then only it is complete. But by that time, the scheme was no longer there. So another lordship, as far as lordship the case laws, my learned friend has submitted. Only thing, lordship, he has submitted lot many cases on promissory estoppel. So as far as promissory estoppel is concerned, lordship, if she is relying on the concept of promissory estoppel, then she should have challenged the withdrawal of the scheme by the government of India. She hasn't done so. So the principle of promissory estoppel will not be applicable here at all. It doesn't have any relevance because she has not challenged the withdrawal of the scheme by the government of India. Had it been, had she challenged this withdrawal of the scheme by the government of India, then the question of promissory estoppel would have come. Then would have been there's different arguments whether government can, as per policy, withdraw their scheme or not. That would have been a different question altogether. So in this case, lordship, promissory estoppel aspect will not be applicable. Since that very withdrawal of the scheme has not been challenged by them. That's that, and as far as lordship interest and all lordship, that is pending before the Supreme Court of India. That issue is still there. Whether in subsidies the interest will be applicable or not. If delayed payment is made by the state government, whether interest will be applicable or not. That I was there in the case, lordship. In the division bench, lordship, it went against me, but that has gone to the SLC. That has gone to the Supreme Court, and Supreme Court, that matter is still pending. That issue is still pending. So lordship, that's my humble precise submission, lordship. I don't have to say anything more on this. Lordship, on the basis of these facts, I don't think, lordship, they have any merit on this in this matter. Lordship may not interfere. My humble.
Lordship, on behalf of lordship, respondent number, lordship.
Who?
Netfee, lordship. Lordship, we are neither a necessary party nor a proper party in this case. In fact, lordship, this entire scheme is under Ministry of Food Processing, lordship. And we have unnecessarily been dragged in the case, lordship. Our name may be struck off from the record. Even in the earlier writ petition, lordship, our name was struck off, lordship. But still knowing this thing, petition has again implicated us in this case.
Respondent 4.
Respondent 4, Netfee, lordship.
Your good name?
G. Das, lordship. This is in order of the earlier writ petition, lordship. Our name was struck off, lordship.
This is already a final, this thing is not required.
Because if it went on an appeal, then again, lordship, we will be dragged into that. They can compensation.
Yeah,
First, regarding my lord, date and other clerical mistake, my lord, I will place 2 decisions, my lord, after some time. Lordship, hand over it to lordship. So, my lord, the Supreme Court has again and again, my lord, in so many decisions, my lord, the clerical mistake, typing error, that should be ignored while deciding a major issues in the case. So, I will place it. So, secondly, my lord, he has referred to page 68. Regarding the decision, I will place it. The clerical mistake or my typing mistake should be ignored while deciding a major issues. Here, my lord, page 68. Although scheme was closed, that meaning thereby that, my lord, from 1st of April 2015, they will not accept any new application. But my application was filed in, my lord, March 2014. So, my lord, that was processed by their GM. Why this document is, my lord, not, although it was necessary not placed, it is the responsibility of the functional manager and GM. general manager, who is the head of the district, he should have verified it and thereafter forward it. That is not, he is their officer, not my officer. He is the accepting authority. So he should have not committed any mistake, accepting all these documents, my lord. So later on, secondly, my lord, they have not written any single letter that, my lord, normally the all office writes, my lord, if any lapses are there, then you file these documents, that document. Not a single letter, I think in the record, my lord, I will say, communicating that you file this, that. My client said when earlier they have submitted, they have misplaced. Again, they have, when they came to the office, my lord, for inquiring, then only they have told there is no telephonic call. It can be, my lord, verified. And there is no other, any single letter communicating that, my lord, that these documents are missing. And they don't have that courage also. Because not a single letter has been written that this document, shortage of documents. Few days back, your lordship passed 2 documents, there was written shortage of documents. Here, where is the letter communicating the petitioner that there is shortage of letters or shortage of any document? Not a single letter. This is afterthought, my lord.
And
After
this
filing.
Kalita, this page 209. When the scheme was delinked on 1/4/2015, what was the necessity to visit the factory on 15/4/2015?
Lordship, that, because they probably wanted to, maybe, Lordship, I'm not very sure, because nothing is written there. Maybe like they wanted to, they were not, at that point of time, they were not properly informed, because this is from the Silchar office. So that's why probably they have visited it. I'm not very sure about this. I don't have any instructions on this, because I have also seen that, and I have also tried to find out if there is anything there. But they have gone there on 15, but they have gone there because they may have gone there on 15 after this thing, but like, only thing is that it was already delinked by that time. But that doesn't create any, create or confuse anything, Lord. Meanwhile, humble submission, that doesn't make any difference in the case, Lord. Only thing is that, Lord, whether the documents, proper documents were there or not. And in my humble submission from the record, it shows that documents are not there. Documents they have given, 2 documents they have given, those are defective documents. Then they have resubmitted those two documents. Those 2 documents that earlier they have submitted, those are already there on the record. Lordship has seen it. One is not, they're not signed affidavit. Then like surety bond, Lordship, that the bond is signed by, witness has been named, has been signed by him only. Then they have replaced it. Then they have to submit those CS certificate. Those documents are not there. There's a list of documents they haven't submitted. In the list, whatever the documents they have submitted on record, those records were, the forwarding letter was not dated, and the CS report as well as bank's certificate, those were post this thing, post delinking. That is the issue, Lordship.
Their officer, the district head, district general manager, mind. He is the authority.
He is only
of-
the
of
recommending
documents.
authority, Lordship.
No, no.
There, he is only the
He is
recommending authority.
verifying. He is verifying authority. He goes for inspection, not only the documents, only for physical verification of the industry. So he is the proper authority for inspection of the inspection of the, my lord, unit, and, my lord, verification of all documents. He has forwarded everything, because not only my case, hundreds of cases might have been forwarded. And thereafter, my lord, again they are asking, there is no single letter or any communication to the petitioner, even if it is closed. And the file was gathering dust. Why from 14 to 2015 March, SLC might have seen so many times, why my file was not placed? Their file was not placed before the SLC. For any, let it be rejected, but why file was not placed before the SLC? That is the main and important point, my lord. SLC should have rejected. There is no rejection letter. There is no record, I think, showing the file was placed before the SLC.
This bank certificate, there's no date.
No date. No
Okay.
data, no. The forwarding letter is no date.
And second, also heard A. Kalita, standing council industrial.
I have to place something, my lord. I have to place 2 points, my lord.
Oh, you want to argue
Yes,
some
yes,
more?
my lord,
Okay.
counter his argument, my lord, because I am yet to give the reply. So
Yes.
there is no communication, no, showing, no sign of placing the proposal before the SLC.
Hmm.
Because the SLC rejected, then I am happy. Okay, something is there wrong. So SLC has rejected. Why they are answerable for that? Why they have for more than 1 year holding the file without any communication or without placing the file before the SLC? 2 point. Number 3 is, my lord, although, my lord, the scheme was closed, but, my lord, the committed liability and ongoing proposals, therefore, my lord, continue till it is complete or whatever fine is required, they will give. That was
No,
understanding.
that is what Kalita is trying to clarify. That after the delinking of the
2018,
scheme on
yeah,
1/4/2015,
Yes,
then
2018,
they continued.
yes,
They
those-
continued for those units
yes.
which was approved by the SLC.
No, other
SLC.
files also. That is, my lord, page 68, what I want to refer, my lord. The additional chief secretary, paragraph 1, 2, 3, 4. Whereas neither the DO letter so-and-so, so-and-so, discontinuation from the union budget so-and-so, report of the committee constituted by so-and-so, dated 19 October 2016, with Sri K.V. Ipan, IS, additional chief secretary to so-and-so, PNRD department as chairperson, recommended, it is important, recommended payment of financial assistance under NMEP against those proposals which were under process. My file was under process, but not approved by the respective empowered committee. That clearly shows my file was partly approved by the, recommended by the GM. It was partly processed. It was under process because it was filed within time. But they have, for more than 1 year, they have not filed before the SLC. And here this understatement reveals that, my lord, this person recommended payment of financial financial assistance under so-and-so against those proposals which were under process, but not approved by respective empowered committees. So, my lord, when it is, my lord, pending approval of SLC, because it was never placed before the SLC. Once it is placed, then only a result will come. But it was not placed before the SLC, but it was under process. Under process, partly the first section they have succeeded. Second section, my lord, yet to be.
Sakya, what this paragraph is saying
Yes,
is saying that the letter of 27th March 2015 and the report of the committee dated
recommended.
19th October 2016 did not recommend for payment of financial assistance.
Did not recommend is not there, my lord.
You read it properly.
Neither so-and-so, 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 informed discontinuation scheme union by the demand, nor the report of the committee constituted by so-and-so, anti the demand, so-so, IPIN secretary, department of chairperson, recommended payment of financial assistance.
Says
Under
neither the due letter so and so nor the report of the committee so and so recommended payment of financial assistance.
Then, my lord, this paragraph will also do. That, my lord, the ongoing projects, your lordship cannot ignore ongoing projects. Page 67, first paragraph. Ongoing projects approved by the SLC. And, my lord, committed liabilities from the state resources. My file was, my lord, under process, and it was not placed before the SLC. Whose fault is it? It is not my fault. Why I should be deprived of the benefit? It is not my fault at all.
That I'll consider.
Yes. And, my lord, they are sitting in the file, gathering dust in the file. And, my lord, the finance was, my lord, approved in the page 64, the letter by the managing the AIDC. It reveals that, my lord, the up to 2017-18 financial year, those pending files were cleared up till, my lord, because in different financial year, different blocks were allotted or selected, because once in a year, it might have been difficult for the government to provide the fund. So my lord, it continued up to 2018. So my lord, all documents are there, and by the GM, they have not written a single letter to the GM or to the party that my lord, you are missing all these documents, so you cannot place it. Where is that at?
Kalita, for a proper adjudication of the matter, because since this court will be writing the judgment, this report of the committee, which was constituted by the notification of 19th October 2016,
Which one, Lordship? Lordship, which is referring to Lordship?
page 68.
Page 68. What is this? Open no naam thaka paragraph question.
Page 68, yes, Lordship.
That para?
I'm sorry. That paragraph I have read only.
Yeah.
DO
letter
letter, so and so.
and committee report.
That Lordship requires this.
Uh,
I'll place this.
you have it now.
I don't, I'll have to look into it, Lordship. I'll have to look. It's not with me, right?
Because and,
Then I'll give it to you.
and then that office memorandum discontinuing the
Scheme.
yeah.
Yes.
I'll pass in my order then.
Yes, Lord, that I'll place it before your Lordship.
Okay.
I'll place
But
it.
MSN cycle and also for the petitioner. Stop now. Mr. A. Kalita, Learner Standing Council Finance Department. Shall produce a copy of the DO letter number MFPI oblique NMFP oblique budget dash 2012 dash 17 dated 27th March 2002. The report of the committee constituted by notification number BB 208 oblique 2015 oblique 34 dated 19th October 2016. And where's that office memorandum somewhere?
The delinking, Lordship.
Yes.
Delinking is.
No.
Page 64, I think. That add is a.
No, not that.
Sure, my lord.
And
Which letter, my lord?
no, OM.
Oh,
Somewhere we have just read. No.
Okay.
The delinking, Lordship.
No, OM. Office memorandum.
I think it's page 67.
Page 67, yes.
The last para.
Yes.
Office memorandum.
Last
correct?
office memorandum, yes. August, 17 August 2015. 67 अच्छा तल paragraph तल paragraph तल paragraph.
Yes.
And the office memorandum number BDP stop 57 oblique 2010 oblique 94 dated 17 August 2015 issued by the Planning and Development Department. By the next date fix. When can we have it?
I will only within 2-3 days I'll place it.
Okay.
Maybe 1 week or so. 1 week maybe.
Today is Thursday.
Next Thursday.
Monday.
Next Thursday.
Next Thursday.
By next Thursday or Thursday also. I can place it before that also.
First.
I'll submit it before the court officer.
First May.
I'll submit it before the court officer. Let's see what matter will be listed.
Matter will be listed.
Matter will be listed. So hearing is completed. So only just those placing first.
List the matter first. Okay.
I'll give the decision now itself.
No, give it on that day.
On that day. Okay.
Then what you can do, you can keep the reports and then on that
Yes.
day.
I'll hand it over.
Obligement. Next
Obliged,
item,
Lordship.
Capital का value नहीं. Send there. Next item में kindly be adjourned. Next item Martin to. Next item में kindly adjournment.
8, item 8.
8th, my lord.
When?
Any date, my lord? Next week.
Okay, on request made by MSN Cycle and
Eight.
council for the
One
petition.
or 8, but 6.
This
6 of
letter-
May. 6 of May.
Yeah,
8 of May.
6 May.
क्या लगा? 6 my lord.
3, 4 and 5.
अब ला जाओ.
May I please, Your Lordship? Lordship, the matters are similar in issue, all the three. Here the case is, Your Lordship, in all the three cases, the contract was terminated in the convenience of the department because there was no fault on the part of this. Now, after the termination of the contract on convenience, they are not releasing the security deposit which was furnished by us. That is the crux of the issue, whether in a case where a termination, the power of termination under the convenience of the employer is exercised when there is no major fault on the part of the contractor, etc. Whether the department are entitled to retain the security deposit and does not. Their main contention is that if I'll take your lordship first, because the letters are common, I'll just take your lordship to page 71 of the
First petition.
4190, your lordship. If it is 4190, page 71, if your lordship.
Mm.
This is a letter dated 23/11/2017. The language in all the three cases of the termination letter are same, except for the contract numbers, your lordship. I just may be permitted to read out, your lordship. In continuance of the letters under reference, I would like to inform you that the undersigned is of the view the circumstances enumerated in your letters mentioned under reference above has merit and appreciate the value. Assigned. So I, Sri such and such, executive engineer, exercise of power conferred upon me under Rule 52.3 and 53.2 of the GCC of the tender agreement to terminate the work on the basis of convenience of the employer and on behalf of the government of Assam, hereby give you notice to terminate the work of the above noted work and package notice signed such and such. So this is the letter.
What was the letter that you wrote?
One of the letters is here, your lordship. That reference your lordship will find letter number nil dated 28/1/2008. Your lordship will find annexure B1, which is at page 69, your lordship.
Hmm.
If I may read out you. We sought for an extension of this. The above package could not be completed within the extended period due to reasons stated above. The road leading to such and such. There are three major bridges. These drainage bridges to be constructed in such and such. The drawing were only for the same ones received by us on this. After construction of two numbers of this, we may be executing the work excluding this such and such. Then there are 6 points we were stated. Then we sought for an extension if the last line on 36/2008. This was the letter, but taking all these factors into consideration, they have terminated at the convenience. And the relevant clause of convenience, your lordship will come at page 61 is the GCC.
Yes.
Clause 52 deals with the terminations under various headings, your lordship. The first is the 52.2 is for fundamental breach of contract when the contractor refuses to work or there are some other fundamental breach on the part, but they have exercised the power under 52.3, just at bottom of page 61, your lordship. Notwithstanding the above, the employer may terminate the contract for convenience. And thereafter, your lordship will find
No,
clause 50
it's under 52.3 and 52.3 and
53.2.
53.2.
53.2 is at page 62. Here, clause 53 deals with what is the payment upon termination.
Okay.
While 53.1 and 53.2 deals with when there is a fundamental breach on the part of the contractor, then they can utilize the security deposit to recover the dues which is there to the department. However, in 53.2, if your lordship, if I may read out, if the contract is terminated and the employer's convenience, the engineer shall issue a certificate for the value of work done, the reasonable cost for removal of equipment, reputation of the contractor's personnel employed solely on the work, and the contractor's cost of protecting and securing the work, and less advance payment received up to date of the certificate, less other recoveries due in terms of the contract, and less taxes due to be deducted at the source as per applicable law. The security deposit is not mentioned to be utilized under this clause. However, for the sake of argument, I'll just like to draw your lordship attention. 53.1 and 53.2 above clearly specifies that in such a case, the security deposits are to be utilized. If I may just read out the two, because those are liquidated damages are there, so they will use, because security deposit, lordship is well aware, it is only to protect the interest of the employer from a negligence on the part of the contractor. Now, once the contractor is not at fault, when it is a convenience, so forfeiting the security deposit amounts to penalizing the contractor for not fault of his, because they have accepted it. The language is explicit. There is no ambiguity in the letter under which the contracts were terminated. The same letters are there on the three different contracts. Only the contract numbers are different here. So their stand is that as the clause 53.2 does not say that the security deposits are to be released, they are not duty bound to release that. And secondly, they have taken a plea. If a lordship takes up their affidavit in opposition, they have filed your lordship. Now, they say that there are some recoveries to be made by them from us, but not a single details have been provided before this honorable court. Neither they have put us on notice any time that there were some dues recoverable from us. Now, they have annexed memorandum of payment, type copy, your lordship will find page 81, annexure A, your lordship. This is, and page 84 is the original copy, and they have typed it out from page 81, your lordship. Here, your lordship will find from clause serial number 4, advance to contractor, there is nothing. Then next page 82, recoveries of advance from contractor, it is stated as nil. Then again, statutory deductions, number 3, there, your lordship will find it is nil. And at page 83, total recoveries, they have given a chart, 1, 2, 3, and 4. It is also stated as nil. Now, there is nothing on record because security deposit, there is it is no longer any doubt when they can be utilized. If the department suffers any loss due to the fault of the contractor. Here, there is nothing on record that they are on fault, our fault, they have suffered any loss. They have not brought on record anything. And in fact, the termination is clearly unambiguous. It is that it was at the convenience, they are terminating it. Now, once it is in convenience of the employer, there cannot be any penal liability upon me because forfeiting the security deposit amounts to putting a penal liability upon the contractor. So that is the whole case before your lordship. And interestingly, however, another point I'd like to draw your lordship's attention. In the affidavit, they have taken a totally different stand, affidavit in opposition. They say that I had abandoned the work. I'll just take your lordship at page 76, which is totally contrary to the termination. Means their stand is not fair to be said because the termination letter clearly says that on the convenience, we are going to terminate, we are terminating it, we accept the same. In para 4, if your lordship sees, in page 76, they take a totally different stand, say that I have abandoned the work. It was never a case. In fact, I had asked for an extension in that one of the letters I had referred. They say, with regard to the statement, the deponent begs to state that the last payment was done since the petitioner abandoned the work. Accordingly, the work was terminated. Work was not terminated on the fact of any abandonment. It was terminated on the convenience. The document itself contradicts their own stand in the affidavit, Your Lordship, which I have stated in my affidavit in reply, though that is thing. But the thing remains, Your Lordship, the contractor, the petitioner before Your Lordship was never at fault. And the respondents themselves had exercised the power of the contract under clause 52.3 and 53.2, whereby they have exercised that at their own convenience, they have terminated. Now, in such an issue, whether the respondents are within their right to withhold the security deposit, that is the thing. Our contention is, as there was no fault on our part, as it was a termination on convenience, the security deposits needs to be released, Your Lord. That is the whole issue before you, Lord. There is no documents on record that there is any fault, nothing they have brought on record, merely statement that I have abandoned. In fact, that very statement is contrary to the termination letter, convenience letter of termination. And we have been asking for release, that is not been done.
The issue is same, my lord, same tender conditions in the other two cases also. Lordship may kindly turn to page 71 for a moment, as Lordship has rightly pointed out. And about 7 letters have been referred to, which are not part of the records.
No, they should have brought it. No,
Of course, I
they
will
have
bring it, but page 71. Lordship will see, my lord, the first letter is of 2007. The last is of 2016. Now, in para 4 of the writ petition at page 6, they have stated that the work was allotted to them in sometime in 2005. So, for my lord, more than my lord 12 years, the particular work could not be completed. For whose reason, my lord, these particular letters will reflect. Lordship will see from serial number 1 to 7 of page 71.
No, but this were addressed to you, no?
So I can place it, my lord, because you will have to see, because in the affidavit you have taken a stand that, my lord, the petitioner has abandoned it. So might be, my lord, there are letters from the petitioner's side that, my lord, he cannot continue with the work.
That is why this 23/11/2017 letter.
Yes, whatever reference are there, my lord, all should be placed. My lord, I can place it.
By which the
Final decision was taken, my lord.
Because they have appreciated the facts. It is
terminated. You have invoked only 52.3 and 53.2.
Lordship, yes.
All right. But then you have referred to the letter on
Yes,
top.
because by considering those reference, my lord, probably this decision was taken. So what is there in this particular reference? Only one document has been placed by the petitioner, which is of 2008. And the order is of 2018.
And there are 5 documents are from their side.
No, I will place, my lord. That's why I'm saying, my lord. To find
5
out that
documents are
particular
theirs.
cause, why it was, my lord, terminated. Be it, my lord, under 52.2.
Okay, heard
That
Mr.
will be.
A. Biswas.
A. Biswas, learned counsel to the petitioner. Mr. B. Gugoi, learned standing counsel,
My lord,
PWD,
Lordship.
Now he-
shall produce all the communications which is referred to in the communication dated 23/11/2017 within bracket annexure C to the petition. How long list on?
My lord, the same letters will be there in the other two cases too.
all the
Lordship will come-
letters in the
Yes.
termination letter, all the letters, because there may be different letters mentioned in
But the
the.
termination order are the same, is it?
No, termination, I mean, the language is same, but the orders are different, dates are same, but the contract numbers and some letters may be different.
No, that's why I'm saying,
Yes.
this 23/11/2017
Yes,
date is
in
the
this
same.
particular case, it is 23/11.
So-
First item is 20.
Second.
I'm just
Yeah.
saying in the
Lordship will post it after 2 weeks, man.
communication dated 23/11/2017,
Yes,
annexure C to the writ petition.
the reference letters, my lord, mentioned in this particular letter, that is 23/11. That I
What
will
did I
place.
say?
Even 23 legally.
Huh?
Yes.
Shall produce all the communications
Lordship,
referred to in the communication dated 23/11/2017.
In fact,
In the other writ petitions also. it is-
the date is same. Lordship will only
Date
refer
is
the
same
date.
except for the contract
Yes.
numbers and this.
So that won't
And
be
the
necessary. Lordship will mention
Others
the
are,
date.
others are also annexure C, or I'll not put.
Annexure C.
Annexure C, your lordship. All are annexure C, I think, your lordship.
In the, in the three. Or don't say annexure C. In the
All annexure
communication-
C, yeah.
In the communication, they did 11 to 12. List after?
After 2 weeks, maybe.
Let them produce, then I may have to.
You.
Oblige them.
Obliged.
Your Honor, Your Lordship, today we have filed our, in item number 9, today morning at 10:30, we have filed our affidavit opposition.
Hmm.
May the affidavit opposition be come to the record after this break?
It'll come, no?
Lordship,
Let's call for the reports, no?
At two may be taken.
No, no, the other cases, you wait for your turn.
Well, here, this is, today it is for consideration of interim.
That's why I'm saying it will reach.
Yes, yes.
Lordship, for item number 6,
Mention it too. When?
20th of May.
20.
20 of May.
Heard Mr. Jain Sahiwala and a senior counsel. Assisted by MS?
Yes, Todi.
S. Dodi, Learning Counsel. for the petitioner. On request made on behalf of Mr.
BK Singh,
PK
BK Singh,
BK Singh,
or BK Singh, Learned Counsel for the respond number,
respondents,
for the respondents, list on
20th of May,
20th of May.
20,
Okay.
20,
20.
20.
Obliged, Lordship.
Lord, I am for respondent number 1. Yes, item number 6.
Your good name?
Sir A. Varali, appearing for respondent number 1 on behalf of SK Media. CGC.
You got it?
SK Media.
SK Medi, Learned CGC, appears for the respond number 1. no? Then it will be 2 to 6. Oh. Yeah, on top. That one.
Nine, admission.
My lord, this case is to be fixed for consideration of interim order.
Hmm.
The lordship may kindly come to.
Before my learned friend starts.
Have you filed your additional affidavit?
Yes, my lord, I have filed.
Enclosing your tender documents?
Yes, all tender documents.
Yes,
Before my learned friend starts,
Ah.
because he praying for interim order. And I am saying the below submitting that this declaration not maintainable at all. So if your lordship so feels that, my lord, I will make submission.
okay. On the maintainability,
My lord, on the territorial jurisdiction. Thereafter, suppression of facts. And thereafter, in each matters, the tender matters out the judicial review, my lord, the court, Supreme Court has said. The writ should not be entertained.
okay.
If you lordship so feels,
Have you filed your affidavit?
well, I filed my.
Oh, has it come?
Yes, call for it. Will be a
Let me, my lord, make submission on the jurisdiction.
1 minute. Affidavit in opposition, you are the respond number 5, Dr.
Yes,
Saraf?
yes, my lord.
Okay, have you taken those grounds?
Yes, yes, sir. I'm taken only on the preliminary grounds. On the merits, my lord, I have not filed the affidavit now.
Okay. Are you willing to file a reply to this affidavit?
I will
or
file
not?
the reply, my lord, but in the meantime, my lord, I would like to make a submission for the interim prayer. my-
See, the
Just
issue
sub-
is just when there is a issue of maintainability raised.
Yes,
Now, how can I consider the interim at this
Now,
stage?
just
Now,
your-
what this court is proposing,
now just your lordship may kindly come.
no,
Yes.
listen to this court. Now they filed an affidavit, not on merits.
Yes, on the
on
jurisdiction
the-
point.
On the maintainability of the writ petition.
Yes, my lord.
All right. Would you like to file a reply?
Reply, yes.
If you want to file a reply, I'll give you a very short date.
Yes, my lord.
Because, and only after consideration of this maintainability issue, we'll
Yes.
consider the interim.
Yes, my lord, yes. It may be mentioned, my lord, in the.
Lord, if you lordship just look into one judgment for my satisfaction.
You're on the jurisdiction point, which were,
Well, I'm on the territorial jurisdiction, as well as I'm making submission of suppression of facts, and as well as the Supreme Court, what Supreme Court has said in the tender matters. Your lordship may kindly see, my lord. Para 25,
this is that NG project.
23, my lord. Yes, my lord.
Oh.
Your lordship is well aware, my lord.
Oh.
May I read, my lord?
Hmm.
In view of the above judgments of this court, the writ court should refrain itself from imposing the decision over the decision of the employer as to whether or not to accept the bid of the tender. The court does not have the expertise to examine the terms and conditions of the agenda economic activities of the state, and this limitation should be kept in view. Courts should be more reluctant in interfering with the context involving technical issues, as there is a requirement of necessary expertise to adjudicate upon such issues. The approach of the court should be not to find fault with magnifying glass in his hands. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender conditions. If the court finds that there is a total arbitrariness or the tender has been granted with a malafide manner, still the court should refrain from interfering the grant of the tender, but instead relegate the parties to seek damages for the wrongful exclusion rather than to injunct the execution of the contract. The injunction or interference in the tender leads to additional cost on the state and is against the public interest. Therefore, the state and its citizens suffer twice. Firstly, by providing escalation cost, and secondly, by deprived of the infrastructure for which the present government are expected to work.
Just.
Now, in this case, the letter of intent has been already been issued. The mobilization has already been started. Work has already started. Now, at this stage, my learned friend is praying for a stage so that whatever things will be there. And on the same issue, territorial jurisdiction, this honorable court also in similar matter, my lord, has held that the territorial jurisdiction, because you had the tender was issued from outside us, the territorial jurisdiction, this honorable court. Now, the tender was submitted there. The decision was taken there, my lord. Now the work is that my learned friend was on the last occasion was part of the cause of action. Part of the cause of action will arise only when the work has been allotted and the work starts. Then only the part of a cause of action will arise in this territorial jurisdiction of this honorable court. But in the similar circumstances, this honorable court has held the territorial jurisdiction is outside the territorial jurisdiction honorable court. And suppression of material facts, my lord. My learned friend has filed an affidavit, additional affidavit. Additional affidavit not become part of the writ petition. He should have filed an amendment petition with the pleadings, because how the additional affidavit can become a part of the writ petition?
This honorable court allowed me to file the additional affidavit.
Okay.
Now, just 1 minute, my lord. Your lordship may kindly come to page 318 of my additional.
No, I'm not going into all
Just
this.
one
I'm
minute.
not going into all this because you're going to file a reply.
Yes.
The respondent number 5, which is represented by Mr. Dr. A. Saraf, Learned Senior Counsel, assisted by Mr. NN Datta, has filed an affidavit raising the issue of maintainability of the writ petition. Stop. Para. Mr. A. Hussain, R. Hussain, Learned Counsel for the petitioner. Praise for how much time you require?
My lord, next week, any date may be given.
Praise for a week time?
1 week time.
Praise for 1 week time to file reply to the affidavit filed by the respondent number 5. So, praise a lot. List down. I'll give you a date.
20.
After 1 week.
After 1 week.
Part 2. 6 June. 6th May.
Let it be on 8th, my lord. 8th May.
8th of May.
Yes.
Okay.
To hear about on the maintainability bill.
That's
Yes.
only. Because in the beginning I've said.
My lord.
And on the matter of interim period, my lord.
First, maintainability you satisfy the court.
I will certify your lordship.
That
They have misread the entire the tender document.
prayer for interim shall be considered on the next reasonable date. Okay. Yeah. You file your affidavit.
We received the copy yesterday night, my lord.
On top you just say, Mr. D. Hazarika, letter counsel for the petitioner, for the respondents, 1, 2, and 4 submits that they filed affidavit. When did you file? This morning. Stop. Registry to verify and place the same on the court. If found in order.
I'm opening.
Okay, Mr. S.S. Roy, Leonard CGC appears for respond number 3. Make a sequence. Okay.
10.
Dear Lordship, I received a Parawai's comment, Lordship, on yesterday, Lordship. It says, Lordship, that now already the additional items are already selling in platforms in other stalls. So it was not given.
Then you file your affidavit.
I'm pressing for interim order, my lord. Because my
What interim?
yearly, my lord, the installment is so high, my lord. It's around my 12 plus, my lord. By selling only, my lord, milk product is not feasible for me, my lord, to earn.
Let him file his affidavit.
For a moment, kindly see, my lord, for a, if my lord allow me to sell the other catering items, my lord, in the meantime.
Yes, what does the instruction say?
My instruction, other stalls which are in platform, they are already selling these items. That's why it was not given.
It is for platform 2 and 3, my lord. I've already annexed, my lord. Platform number 1, I have a, my lord.
Where is the notice?
Yes.
The notice.
But MP notice is, my lord, page 89, my lord. There is how it is to be a that is not also, my lord, reflected from the order, my lord. It is a established practice of the railway, my lord. Because the reserve price is too low, my lord. And I have quoted, my lord. The reserve price is 3 lakhs, my lord. I have quoted 7 lakhs, my lord. And by adding, my lord, GST and other taxes, my lord, is around, my lord, 12 lakhs, my lord. Per year, my lord. The LOA, my lord, page 80, my lord. And the work order is page 83, my lord.
One minute. Yes. Page 83.
83 is the work order, my lord. Now, kindly see the annual license fee, my lord. Milk is 7,69,999. And my lord, the reserve price is at, my lord, page 27, my lord. After tender paper, my lord.
Page?
Page 24, my lord. The reserve price per annum, my lord, is rupees for 3,50,400 rupees, my lord. Why, my lord, I have quoted, my lord, so high, my lord. And I will highlight, my lord. Now, can you see the other work order, my lord, where I have participated, my lord.
Where is that?
Page 90, my lord, the other.
Page?
Page 90, my lord.
90.
Yes, my lord. It is a tender paper for platform number 1, my lord. Relevant portion is page 92, my lord. I see, my lord, the reserve price per annum rupees 2,65,000. And my price, my lord, see, my lord, page 148. My annual license fee, my lord, plus 3, my lord, 7,93,999. It's around, my lord, 7 lakhs. Annual license fee, my lord.
Yes, Roy, I think some urgency is involved in this petition.
Yes, my lord, some urgency is there, Lordship.
Then when can you file your affidavit? Weeks, man. No. I'll give you 1 week time. By that time you file it. Because some urgency is involved here. There's no interim order in favor of the petitioner also.
In the middle, if my lord allow me to sell my.
No, that one.
Yes.
But Mr. S. Bhattakur, Learned counsel for the petitioner, Mr. S.S. Royal and CG submits that he has received instructions and prays for 1 week time.
Yes, my lord.
To file contra affidavit, prays list on
30.
On second,
second,
Lordship, let it be on 5th. For Sunday.
let it be on 6th, then if you want it on a hearing day.
Let it be on 5th, Lordship. Second, I will not.
30 local. 30 April. 30th April, madam.
30.
Yes, madam.
That will not be 1 week.
Not be, that's why, Lordship.
7 local.
Okay, then let it come up on 5th.
5th, I'll be out to go like my lord. 7.
Then give a date when both of you are around.
40.
I'm saying there's some emergency and
Yes, but I have an emergency, my lord.
Lordship, let it be on 13th, Lordship.
That's why I pray for in the meantime, my lord, if
13th, Lordship.
allows me but to
Monday. Because on that week, I will not be there in
Okay, 13th.
Lordship.
can I pray for interim, my lord? In the meantime.
Not now.
11, hearing.
Please, my lord. My lord, in this writ petition, we are challenging one notification, which is at Pramanisha F, page 41, my lord.
Page 40.
41 of the writ petition, my lord.
Correct.
So, my lord, if I may be allowed to read. In
Yes,
exercise of,
all parties are represented. You are here?
my lord, the Assam Cha Shramik Sangha, my lord, there's no representation on their behalf, my lord. There was an IA which was allowed on 22nd of August 2017, my lord.
1 minute.
Assam Cha Mazdoor Sangha, my lord. They were included, my lord, as party respondent number 4. Their names have been reflected in the cause list, my lord. In fact, they have also filed their affidavit, but there's no representation on their behalf, my lord.
Assam Cha Mazdoor.
Sangha, my lord.
Assam Cha Mazdoor. You are appealing for?
I am for 123, madam.
One.
But they are the party in the tripartite agreement, madam. The conditions were accepted as an association.
Yes.
So that's why
Then,
they are the
On P. Kalita is there, isn't it?
Yes, my lord.
Who's this P. Kalita?
I don't know. Mrs. Abha Bhattacharya's name, madam. He is with his colleague, junior colleague.
A. Bhattacharya. That
They are the
senior counsel.
member of the
Well. Oh, the lady. Okay.
In fact, my lord, there has been a subsequent notification which has been issued by the government, which in fact is contradictory to what has been challenged in the writ petition, my lord. If I may be allowed to supply a copy of the same, my lord.
You were mentioning that which,
My lord, so the impugn notification is at page 41, annexure F, my lord.
yeah, on what grounds are you challenging this?
So, my lord, we are saying that this notification violates Rule 23(4) of the Assam Minimum Wages Rules 1952, my lord. So, my lord, there are ordinary daily rated workmen who are employed in the tea gardens of Assam, my lord. So, there is a formula which is there to calculate their wages, the minimum wages. Say, for example, my lord, if they are paid rupees 10 per day, then in a week it becomes 70 rupees, my lord. That 70 rupees is divided by 6 so that they are paid even for the rest day, even for Sunday. But my lord, the impugn notification, which is at page 41, it says that they will be paid extra even for the rest day. In exercise of the power conferred by clause A of subsection 1 of section 3, read with subsection 2 of section 5 of the Minimum Wages Act 1948 and provided under Rule 23(4) of the Assam Minimum Wages Rules 1952, the Governor of Assam is pleased to notify that ordinary unskilled employees daily rated employed in the tea plantation of the state payable for the rest day in every period of 7 days in addition to the working days to which an employee is entitled under the provision of the Plantation Labor Act, my lord. My lord, we are saying that this notification violates Rule 23(4) of the Assam Minimum Wages Rules, which in fact lays down the formula to calculate the minimum wages, my lord. Pursuant to the writ petition being filed, my lord, there was one notification which was in fact issued by the government of Assam, my lord, wherein it is stated that
No.
You have a copy?
No one. And if she brought it in the way of my lord application, but that I can also take instruction in that case if at all, my lord.
My lord, if my lord comes to the second page, my lord. So the calculation is given, my lord. The supply of food stuff at concessional rate at so and so, dry tea supplied so and so, firewood compensation so and so, statutory benefits, earned leave, festival holidays so and so. If my lord comes to the third paragraph, my lord, the rate of wages so fixed includes rest day wages, that is 7-day wages is included in 6-day wages as per prevailing practice, my lord. So, my lord, the government itself is following this particular notification. So, this contradicts what has been challenged, my lord. So, if my learned friend, my lord, she can obtain the instructions, my lord, so far as this notification is concerned.
Yes, I can take instruction, but whether this will be applicable at that time, because my lord, when the order was passed, it was subsequent.
This was of 2014 notification. And the next, this president is
22 July 2015.
2015. The which notification which is under challenge is 2014.
Yes, my lord.
14.
And this is the notification which
No,
is in force, my
No,
lord.
no. This is a draft notification.
My lord, this has been published in the Gazette, my
No,
lord.
that's why. This is a draft notification. And it is published for information of all persons to be affected. All objections, suggestions filed in this regard should be furnished to the Secretary, Government of Assam, within a period of 60 days. Then only thereafter they will finalize it. Read the first page.
My lord, this is the subsidy.
Yes. Proposal is hereby published for information of all likely to be effective hereby. Objections decided. Gazette.
This notification was published in the Gazette.
Yes, my
That's
lord.
all.
My lord, this notification is in force, my lord, as of now.
I don't think so.
My lord, because just now I have received it. And if it is
That is
better
my,
if you
that is my
you
instruction,
would have
my
got
lord.
it by a,
Can you file a
My lord, I'll file an affidavit.
that will be done, I can.
My
take
lord, they give
instruction.
me
MS
N Upadhyay, my lord.
N. Obadiah, Learned Counsel for the petitioner submits that there has been certain developments after filing of the present petition. And she prays for filing an additional affidavit to bring those developments on record. Praise a lot. List after?
10 days, my lord.
Okay, list the matter. You want a date fix or?
My lord may fix a date.
No, then I'll say list the matter after 2 weeks.
2 weeks, my
Okay.
obliged.
After that, you give her a copy in advance.
That
My
I'm
lord.
filing
And then
since-
you
my lord.
I'll
take
serve a copy.
instructions.
Obliged.
13.
Where's the union?
Union,
SSR was the worst respondent to.
it just left, I think, SS1. Who is the Union Bank Employees Union?
Hmm?
Union Bank Employees Union.
That is your bank's,
Employees.
your employees.
Yes.
They will list some other date then. Heard M. Sharma, then I counsel for the petitioner. None appears on behalf of the respondents. List after
2 weeks,
2
maybe.
weeks.
14.
All are represented.
Here in this case, I have been appointed as an amicus, my lord.
My guess on behalf of
Respondent number 2, my lord.
2. Okay.
That is the management of Assam.
Assam Government Commissioner cum Consulation Officer. Okay, yes. Then one may have nothing to say.
My lord, this writ petition is filed challenging an order passed by the Labour Court, my lord. In fact, the petitioner, the workman, my lord, he has challenged the order of termination. The reference was made again in respect of an order of termination made by him. My lord, may I just take your lordship to the order passed first, because my lord, I will kindly come to the first page 14. With 24 hours notice, my lord, the termination was the page 14 is the first shock cause notice, my lord. Page 14, lordship got it, my lord. Annexure B. My lord, the petitioner is Gidarto Pathak, assistant director. There is a written complaint with documented proof against you by Srimati So-and-so, Bureau Chief of the Press Trust of India, Guwahati, that you had used her name in the list of members of the Journalist Union of Assam for procuring legal license from the Excise Department. She is not a member of this union, and you have not taken her permission in either verbally or in writing to include the name of the list of the members. This is a serious complaint. You are hereby asked to show cause within 24 hours. Next page is the reply, my lord. Lordship will kindly see. Next page is the reply given by him. in response to your letter, show cause, I would like to state that Journalist Union of Assam is a democratic body registered under the Trade Union Act and affiliated to the Indian Journalist Union and International Federation of Journalists. Each and every decision, including the matter membership of the union, is taken by the executive body and endorsed by the general body of the union. The president only chaired the meeting and signed the proceedings of the meetings. No individual office bearer of the union can act arbitrarily, and she cannot held solely responsible for the decision. The issue of membership of Srimati So-and-so is between the Journalist Union and Assam, of Assam. She is unnecessarily drawn with the Assam Tribune management. She is not an employee of the Assam Tribune, my lord, union. Next, my lord, came the second show cause notice, the page 16. Further to the notice dated so-and-so, the management has received another written complaint by a group of senior journalists of the Assam Tribune, namely so-and-so, Patwari, and so-and-so, 3-4 names, that their names were used unauthorizedly by you in the name of Journalist Union to procure liquor license from the Excise Department. You had not taken the permission in either writing so-and-so. This is a grave misconduct. Same notice within 24 hours reply. Next page is his reply, my lord. Next page is reply. In response to the show cause notice so-and-so, I'd like to state that my stand on the issue is the same, reply so-and-so. Further, if further complaints come in this regard, you please refer those to the Journalist Union of Assam, which is a competent authority on this matter. The next, my lord, then the page number 18 is a fresh notice, my lord. It has come to a notice that of the management along with the documented proof that you have written a series of editorial articles in the editorial page of Dainik Agrodut and so-and-so, dated so-and-so, so-and-so. This is serious breach of well-established and time-honored norms of journalism followed by the newspaper group. You have gone against the ethics of your profession when you contribute the rival newspaper, neglecting your own. It is clear that you were writing this paper on the regular basis. In this context, you were given a last warning, so-and-so, for unprofessional conduct. The management cannot condone utilization so-and-so. You are hereby show cause within 24 hours, again 24 hours. The next page is reply, my lord. In response to your notice, I would like to state that I have not authored any editorial in Dainik Agrodut mentioned in your show cause notice. Moreover, the standing order amended so-and-so, so-and-so, working leaders not barred has not barred working journalists, Assam Tribune, to write other newspapers. Now comes the final order of penalty. 24 hours notice in each time. Your replies to the show cause notice dated so-and-so only confirm your unauthorized use of names of numerous journalists, including staff of Assam Tribune, and including some journalists, not even members of the union, for procuring a license from the Excise Department selling liquor. You may consider it to be a matter between you and the journalist concerned. However, as you are a staff member of the Assam Bani, the sister publication of the Assam Tribune Group, the management is virtually concerned and shocked to learn about your deceitful activity for the purpose highly undesirable for a journalist of a respectable news organization. As regard your reply, show cause notice so-and-so, from the comparison of the handwritings of the copies sent to you by Agrodut publication and public so-and-so, and the copies sent to Assam Bani, it becomes abundantly clear, they themselves compared, clear that the articles published in Agrodut were written by you. You are no doubt aware of the offering services by the employees to the other organizations strictly prohibited. Your above actions have tremendously harmed the goodwill and credibility of the organization, which has built up so-and-so 75 years. The moral turpitude involved in your case is very grave in nature. As such, further continuation of your association with the organization is considered highly undesirable and detrimental so-and-so. In view of above, management decided to terminate your service. So this way, he was terminated. Now, after that, my lord, what happened? I raised the dispute. Conciliation did not take any measure. Thereafter, my lord, the reference under section 2A, read section 10 of the industrial dispute was raised. Now, I filed my written statement before the labor court. My lord, under the labor code, my lord, under the provisions of the, my lord, Industrial Dispute Act and the larger bench division of the Supreme Court, which has referred to it, there is which says, my lord, that if the management wants to prove, if the management finds that if I take the plea, laborer takes the plea that there was principle of violation of principle of nature, that there was no inquiry, then the management can take a plea in their written statement at the first instance, that if this tribunal or the labor court finds on a preliminary issue that the inquiry was not fair or there was no inquiry, the management may be given an opportunity to prove the charges for the first time before the tribunal. That provision, the Supreme Court has clarified it. I have placed before your lordship the decisions. Here, my lord, what happened? I filed my written statement, I adduced my evidence. Then thereafter, what they wanted to do is, my lord, they wanted to prove the charges for the first time before the tribunal, my lord, relegating the tribunal, the labor court to be an inquiry officer. Then they wanted to lead evidence for the first time here. So the Supreme Court says you can do it, but you must in your written statement at the first instance say that if the tribunal finds the inquiry was not proper, then we may be given an opportunity to adduce the evidence. Unless you take this plea at the first instance, you cannot at a later stage, after evidence led by the workman, adduce evidence for the first time. This is what the Supreme Court has said. Now, my lord, I have raised this plea when they wanted to adduce the evidence. My lord will kindly see the page 16 once again, page 16. My lord, they wanted to bring page 16, your lordship got it. The names are there, Ajit Kumar Patwari, so and so. They wanted to bring all these witnesses for the first time before the labor court to prove the charges. When they, without holding an inquiry, terminated my service, they said if they wanted to prove this, with their evidences, with their witnesses, and the tribunal may thereafter decide whether I committed misconduct or not. This cannot be done, my lord, as held by the Supreme Court. So what I did, my lord, when they wanted to lead evidence for the first time, I raised an objection. I said, you decide at a preliminary issue for the first time whether there was an inquiry or not. And if there is no inquiry, then the question is different. Here, my lord, when they wanted to adduce evidence, when my objection is raised, the tribunal, the labor court said, since you laid your evidence, let them lead their evidence. This cannot be done, my lord, as held by the Supreme Court. I'll place before lordship the decision, relevant part of the decision of the Supreme Court, my lord. I'll just read the relevant part of the judgment, my lord. No, Shankar, no. What? My lord will kindly come to page 437. Citation is 2001 5 SCC 433. I read the first paragraph first, my lord, because the background of the case, I'll just go to the background, my lord. 437, lordship got it, my lord. I'll read it, my lord. The appeal is referred to a bench of 5 judges based on the following order made by a bench of 2 judges. In view of the conflict of decisions of this court in Shambhunath Goyal versus Bank of Baroda, Rajendra Jha, presiding officer, Labor Court, we are referring this matter to a larger bench, which has to be bench of more than 5 judges. Mr. Rao and counsel appearing for the respondent states that there is no conflict in the decisions. According to us, that submission is not correct. Hence, we are referring to larger bench. Now, my lord, paragraph 3. Shambhunath Goyal, Bank of Baroda, so and so, has held the rights which the employer has in law to adduce additional evidence in a proceeding before the labor court or industrial tribunal either under section 10, here it is under section 10, or section 33 of the Industrial Dispute Act, questioning the legality of the order terminating the service must be availed of by the employer by making a proper request at the time when it files its statement of claim or written statement and makes an application seeking either permission to take certain actions or seeking approval of the action taken. This decision was rendered by a court while deciding at a stage at which the management is entitled to seek permission to adduce evidence in justification of its decision taken on the basis of domestic inquiry. Rajendranath Swenso, though this court was considering a similar question, we find that the court did not lay down any law contrary to the judgment of Shambhunath Goel case. A perusal of the judgment of this court in Rajendra case shows that the court decided the case on the facts and circumstances of the case only. It is clear from the following observation of the court as so. Thus, the order passed by the Labour Court allowing employers to lead evidence has been accepted and acted upon by the applicant. He has already given a list of his witness and has been cross-examined. There it was cross-examined. Examine the witnesses whose evidences led so and so. It would be wrong at this stage to undo what has been done under so and so as order of the Labour Court. Besides, the challenge made in the appellant to the order of the Labour Court has failed, and the order of Patna High Court dismissing so and so. Thus, it is seen from the above observation that Rajendranath Jha case that the same is decided on the facts of the said case and without laying down any principle of law, or has the court been opposed to Shambhunath Goel so and so. Now, next paragraph 8, my lord will kindly see. Para 8. Before you proceed to examine this question any further, it will be useful to bear in mind that right of a management to lead evidence before the Labour Court or the industrial is in justification of its decision under the consideration by the tribunal or the court is not a statutory right. This actually a procedural law laid down by this court to avoid delay in multiplicity of the proceedings in disposal of the disputes between the management and the workmen. The genesis of this case can be traced by notice so and so before this also. The several cases are discussed. Ultimately, my lord will kindly come to para 16. All this decision, earlier decision was discussed. While considering the decision of the Shambhunath Goel, we should bear in mind that the judgment of so and so therein does not refer to the case of Cooper Engineering. However, the concurring judgment of the Desai specifically considers the case. By the judgment of Goel case, the management was given the right to adduce evidence to justify its domestic inquiry only if it had reserved its right to do so in the application made by it under section 33 of the Industrial Act or in objection that the management had to file to the reference and made under section 10 of the Act, meaning thereby that the management had to exercise its right of leading fresh evidence at the first available opportunity and not at any time thereafter during the proceeding before the Labour Court or the tribunal. Keeping in mind the object of the providing opportunity to the management to adduce evidence before the tribunal or Labour Court, we are of the opinion that directions issued by the case of Shambhunath Goel case need not be varied. That is what the Supreme Court has held. Being just and proper, there can be no complaint from the management side for this procedure because this opportunity of leading evidence is being sought by the management only as an alternative plea and not as an admission of illegality or in the domestic inquiry. At the same time, it is also of advantage of the workmen inasmuch as they will be put to notice of the fact that the management is likely to adduce fresh evidence. Hence, they can keep their rebuttal or evidence ready. This procedure also eliminates the likely delay in permitting the management to make belated application whereby the proceedings before the Labour Court or the tribunal would get prolonged. In our opinion, the procedure laid down Shambhunath Goel case is just and proper. There is one more reason why we should accept the procedure laid down in the Shambhunath Goyal case. It is to be noted at this stage, judgment delivered so and so. It has taken note of the almost all earlier judgments of this case and has laid down the procedure for exercising the right of leading evidence by the management, which have neither held oppressive or nor contrary to the object of the scheme of the Act. The judgment having held the field nearly 18 years, in our opinion, the doctrine of stare decisis requires us to approve the said judgment. So, the Supreme Court has held that if the management, if there is, I take the plea that there was no inquiry, or there is a complete violation of principle of natural justice, then the tribunal will decide it as a preliminary issue, whether there was an inquiry or not. And if tribunal finds that there is no inquiry, then if the management takes this plea in their written statement, the first instance, give them opportunity to adduce, otherwise not. So here, management did not take this plea. They filed the written statement. I filed my written statement. Taking specific plea, there was no inquiry at all. And by giving 24-hour notice, my services were terminated. Then after I adduced my evidence, they now wanted to adduce evidence to prove the charges here before the tribunal or labor court. This is impermissible. And I raised my objection. The tribunal, the labor court rejected my prayer, my lord. So my prayer before lordship is that if now also the tribunal, the labor court want to go into whether there was an inquiry or not, let them decide in the preliminary issue. And if it is decided that then the matter ends, my lord, they will not be able to get the opportunity. Whatever material they have, they will only produce that. The show cause notice or the reply, whatever is. They cannot be given the opportunity to prove the charges for the first time here. They have not taken this plea in the written statement. They simply says, I admitted the charges. Where I admitted, I read before lordship, my lord. And my service cannot be terminated like that, giving 24-hour notice. I'll read the relevant part of the order, my lord, passed by the tribunal labor court.
Where's the order?
My lord, the order is at page 84.
Records are here. Oh, this one.
Records are here, my lord.
Page 84.
Yes, 84 is the order. I'll take the last part, my lord. The page 89. Here I cited the decisions of various decisions of the Supreme Court. Page 89 is the relevant part of that. While arguing, both parties have argued the case on merit, but at this stage, court would not go on the merit of the case. Court would only decide the preliminary, whether preliminary issue is required to be framed at this stage, the cross-examination of witnesses. From the record, it appears that already issues are framed. Evidence workman side is closed. Management side also adduced evidence, 13 number of witnesses, and the case is pending for cross-examination management. Proposed preliminary issue may be decided in the main case. And so in the case before, if in the aforesaid premises, I am the considered framing of preliminary issue also. Now, my lord, they wanted to adduce evidence that cannot be done. The Supreme Court has held, you must at the first instance say that I want to adduce evidence. If you do not, because I led my evidence, knowing well that there is no evidence from their side. I adduced my evidence. After I adduced my evidence and cross-examine me, it is only then they thought it is better. We should try to prove our cases for the first time here. This cannot be done, my lord. It is not that they are barred from adducing evidence. They can adduce evidence on the basis of material they have already. The management witness may come to prove the material they had they cannot seek to adduce fresh evidence here. My lord will kindly have a look at page, section 11A of the Industrial Dispute Act.
That issue cropped up after your evidence was closed.
Yes, after my evidence was closed, they wanted to produce evidence. Before that, they
And there were 13 numbers of witnesses were also examined.
no, it was not examined. They are given only the list. No, they are given the list of the evidence and so and so. And
Here it says,
they
management site has also adduced evidence of 13 numbers of
13 number of this list of evidence and the
okay, list of evidence.
list of evidence, and they are given,
List
but
of,
they were not cross-examined. None was cross-examined.
list of witnesses.
Yes. A list of witnesses and the evidence also given. Then chief, they were not cross-examined.
No, but if you read it properly, page 89, the lower portion,
89 years.
it says management site has also adduced evidence of 13 numbers of witnesses.
Yes, they have.
And the case is pending for cross-examination of management witness.
That's right. That cannot be done. Witness means they
So-
given evidence in chief.
Management witness were also examined.
No.
It was examined by way of an affidavit. These 13 persons had given their evidence in chief by way of affidavit.
Okay.
And
that's
it was
why-
not cross-examined. That is how the court says that
Yes,
they were
yes.
examined on the basis of affidavits.
Affidavits. No, nobody came, my lord.
Okay.
Nobody was cross-examined.
That is not recorded here, that's why.
Right. Now, my lord, this then only I raised, when they submitted this chief and the list of witness, I raised objection. I said you cannot do it now. Because the Supreme Court has held. If you wanted to do it, you must take at this plea at the first instance. That before that, after that, you cannot take this. Because this is a larger bench of the Supreme Court is held. And my lord will kindly have a look at section 11A of the Industrial Dispute Act. Lordship got it, my lord. 11 capital A.
Yes.
Power of the Labour Court Tribunal so and so gives so and so. When an industrial dispute relating to the discharge dismissal of a workman has been referred to the Labour Court Tribunal or National Tribunal adjudication, and in course of adjudication proceeding, Labour Court, National Tribunal, as the case may be, is satisfied that the order of discharge dismissal was not justified, it may by an award set aside the order of discharge dismissal or direct reinstatement of the workman on such terms and conditions, if any, as it thinks fit, or give such other relief to the workman, including the award of a lesser punishment in lieu of discharge so and so, in case may, provided that in any proceeding under this section, the Labour Court Tribunal or National Tribunal, as the case may be, shall rely only on the materials on record and shall not take any fresh evidence in relation to the matter. So, my lord, the case is clear. They have issued a shock cause to me, asking to reply within 24 hours. I replied. Second shock cause, the same 24 hours time, I replied. Third also. All these shock cause notices are taken together and terminated straight away. They go. No inquiry. So, Supreme Court has said there must be an inquiry. If you do not hold an inquiry, the order will go. But to shorten the litigation, what happens? If the order is terminated, set aside, they will again hold an inquiry. So, Supreme Court says shorten this process. They may be given, but they must take this plea at the first instance. I have annexed their written statement. I filed their written my written statement where I've taken specific plea that there was no inquiry at all, and it is evident from the record. So they have not said that they held an inquiry, said I admitted the charges. And therefore, there is no question of adducing evidence. The tribunal cannot be an inquiry officer at that time. You held an inquiry, terminated me without notice. So my prayer is, my Lord, Lordship will set aside the order, direct the labor court to proceed, my Lord, on the basis of material they have, not fresh evidence. The fresh witnesses cannot be brought to prove the charges for the first time, since they have not taken the leap, a plea in the written statement.
Okay.
There are other judgments also similar, but then this is the one, my Lord, which finally decided, and this holds the field. Though, my Lord, the Industrial Dispute Act rules provides the evidence the leading of evidence, that's right. The court can also ask, you adduce evidence. This is the court's power. That is different altogether. If the court is not satisfied with the material, court can say, so already you adduce evidence. That is court's power. It is not the, and Supreme Court has held there is no statutory right. My Lord, I have read it before Lordship. There is no, it is not provided in the statute that there is, as a statutory right they can ask for evidence. There is no power. Supreme Court has clarified it.
Okay.
My Lord, I think I need not bother your Lordship with the other materials that I filed, the written statement and all. Because the impugn orders are very clear.
In the first written statement, there was no.
None. None at all. I filed it, my Lord. I can show
the records.
Yes, yes. Okay. I can show it to your Lordship.
Is it page 141?
No, my Lord, I file all this by way of supplementary affidavit.
Supplementary affidavit.
Additional affidavit, my Lord, additional affidavit. That was filed, my Lord, on 17/8/2016. আমার কপিটা অফিস কপিটা ধরুন তো আন্ডারলাইন করা আছে এটাও দেওয়া আছে My Lord got it.
Yes. That's why that's on page 141.
My Lord, running page is page 97. Huh? 99. This is my page 99 is my application, my written statement.
Correct.
My Lord, page 106. 106 is my plea. Paragraph 13, Lordship got it. Page 106, running page.
Yes.
I said that the applicant states that show cause notice were issued by the applicant so and so stop within a short gap of 1 month. Clearly goes to show the management has made up their mind to punish the applicant so and so, the manager Adambani so and so, without even following the manner provided laid down in the standing orders or gross violation of principle and legis, has terminated the service of the applicant issuing order so and so. The order of termination to be issued giving complete go by to the rules of procedural safeguard, guaranteed journalist certified standing order so and so. Now, my lord, their reply is also I have annexed. I quoted the relevant provision of the certified standing order where says natural principle, natural justice ought to be followed. And then again, para 16, I said the same thing, my lord. Para 22, again, I reiterated. And said, my lord, specifically, in para 22, my lord will kindly see that the applicant states that page 119 state that in view of the fact the order of termination is passed in gross violation of principle of justice without following the detailed procedure, this honorable throne may take up the sustainability or otherwise of the order so and so, breach of so and so by a preliminary issue. That a specific plea was taken by me in terms of the Supreme Court judgment. Then I filed additional written statement. Their written statement is page 141. And their plea is only, my lord, paragraph 19, page 146.
Yes.
Their plea, the applicant submitted the replies for all these show cause notices and has not denied the allegations leveled against him, confirmed by him on unauthorized use of the names of member journalist union so and so, and has not taken the plea here, alternative plea here, that in the event the tribunal finds, labor court finds that there was violation of principle of general justice, then they may be given an opportunity. It is their written statement. No plea is taken. They have even filed an additional written statement. They are also at page additional written statement. There also they have not taken in the plea. At page 153. So the labor court must decide on the basis, they can adduce evidence of their management on the basis of material they have. They cannot seek to prove their charges here. That's my humble submission, Lord.
Chakravarti, what we'll do? Can we keep it as part of
Lordship,
the matter?
Can it be taken up on next Tuesday? It won't take much time, my lord.
We don't take time.
Because, my lord,
Please
preliminary,
take up.
before I place the judgments, I'd like to submit two things, man. Here there are two aspects. First, the charges, and number two, the procedure to be followed in the labor court. So for the charges are concerned, my lord, it is yet to be decided by the labor court. So I need not trouble your lordship by submitting what and how the labor court will decide. The first question which requires an answer from this honorable court is whether the employer has a right to adduce evidence before the labor court to establish the charge. If that is there, my lord, then, my lord, there is nothing wrong in this order. Now, the argument advanced that there has to be a pleading and a permission to lead evidence, it applies only when there is a domestic inquiry held prior to issuing the order of punishment. In such a situation, my lord, a preliminary issue is framed before the labor court to examine whether the inquiry was fair or not. If the inquiry is held to be fair, then the labor court decides the quantum of punishment. If the inquiry is decided against the employer, if it is held that it is bad, then my lord, the employer gets an additional opportunity to establish the charge on its merit by leading additional evidence. In that event, my lord, that opportunity is given to the employer only when he pleads in the written statement that I need to adduce additional evidence. Now, my lord, for a moment, lordship, if your lordship,
I'll hear you the next.
my
time.
lord.
Heard Mr. Pikira. The senior counsel accepted by Mr.
SK Chakravarti.
Leonard counsel for the petitioner. Also heard Leonard, MS. UDAS was appearing, isn't it? MS UDAS. Okay, Mr. R. Talukta, Leonard Governor Advocate for the respond number 1, and Mr. S. Chakravarti, Leonard Amicus Curie on behalf of the respond number 2. 13 part list for further hearing on
First,
No, 29th, Tuesday, 29th.
no, 29th. No, let it be on first minute.
okay, first me.
15,
I think I'll rise.
In this case, I'm appearing, non-appearing on behalf of the respondent.
None appears. Okay, heard A. Dasgupta and the senior counsel assisted
for
by
the
MS
Bidas.
Bidas for the petitioner. None appears for the respondent. List after
Any short date given?
1 week.
16,
Here, my lord, I am representing the workman. Here I am representing the workmen, and it is against an award passed by the Labour Court, which is under challenge by the management of Punjab National Bank. Senior counsel, Mr. S. Datta, appears in this matter. I don't know. Junior was there. Hey, come on.
I saw his junior.
Yes, his son was also there some time back, my lord.
Yes, son was there.
So, my lord, since the senior counsel is not available.
Okay, none appears for the petition. Mr. S. Chakravarti, you are appearing as a counsel.
Yes, my lord, as a counsel for the workmen.
Learned counsel appears for the
Sole respondent, my lord.
For the sole respondent. When do you want?
My lord, it is for the petitioner. Mr. Datta will be
List
late
after 1 week.
after 1 week. On a date, my lord, otherwise it suddenly comes, my lord.
But then he's not here. It's always after 1 week.
17,
This is a short issue, my lord. In fact, the impute order has lost its force by elapse of time. This is an order of
1 minute. Doctor, I've recorded your absence.
Your Lordship, I prayed, I would have prayed for adjournment for a week.
You're praying for an adjournment.
Yes, sir.
Okay, then do one thing. Cancel it. Mr. S. Datta, Learned Counsel for the petitioner. Prays for listing of this matter after a week.
Much of
Mr. S. Chakravarti appears for the sole respondent. List after 1 week. Yes.
This is short, my lord. The impugn order is 13/5/22 and 18/5/22. The page 39 and 40. By elapse of time, my lord, this is an order of blacklisting the petitioner. From
1 minute. 13.5 says until further orders.
But the rule says, my lord, it is for 2 years, my lord. The rules, my lord, lordship will find.
1 minute. This 18.5 modified the 13.5 2020 order,
Yes, my lord.
correct?
Yes.
And this 18.5 2022 order says until further orders.
Yes, my lord. But it is contrary to the rules.
Where's the rules?
Rules, my lord, lordship will find at page 52. General Financial Rules 2017.
JFA.
Lordship.
Page?
Page 52, my lord. The relevant portion lordship will find it at page 54.
Department.
Debarment from bidding. What are the conditions, my lord? If he is convicted, if it is a case under Prevention of Corruption Act, is IPC involved, then the bidder will be debarred from the last paragraph, my lord. Not exceeding 2 years.
Where is that? Where is that?
Last 3, my lord. Rule 151, sub rule 3. A procuring entity may debar a bidder or any other successor from the participating in any procurement process undertaking by it for a period not exceeding 2 years.
Okay.
So that 2 years is already over, man.
Shama?
Lordship, I am paying for an adjournment. Mr. I.M. Das will do the case, Lordship. So he's-
Okay, RM does fine if he's appearing in the matter, that's not an issue. But then, like the council has just pointed out, page 54, if there is a debarment, if there's a blacklisting, it is usually for maximum period of 2 years. Now that order was passed in 2022. And now we are in 2025. So the order has lost its force. Tell him to take that instructions and come back. Okay, on the next date. Heard, Mr.
Yes, sir.
Yes, Shamal and Council. On request made on behalf of RM Das, the Senior Standing Council Water Resources Department. List the matter when?
In the next week.
After 1 week.
Yes, ma'am. Some date. will be given, ma'am. As per your lordship
Give a
number.
date.
7.
Or we can have it on a hearing.
6.
6th.
Of like.
Any other matters? Over.